ಏನ್ ಮೆಮೋಸ ವೇಟ್ ಮಾಡ್ಬೇಕು. ಸೀರಿಯಸ್ ಥ್ರೆಟ್ ಎವಿಕ್ಷನ್ ಆರ್ಡರ್ ಆಗಿಲ್ವಾ? ಆಗಿದೆ ಅದು ಆಗಿಲ್ಲ ಮತ್ತೆ ಥ್ರೆಟ್ ಆಫ್ ಎವಿಕ್ಷನ್ ಹೇಗಾಗ್ತದ್ರಿ ವಿತೌಟ್ ಡ್ಯೂ ಪ್ರೋಸೆಸ್ ಆಫ್ ಲಾ? ತೊಗೊಳ್ಳಿ is the date before the trial court. ಏನಕ್ಕಿದೆ ಎವಿಡೆನ್ಸ್ ಆದ್ರೆ ಏನಾಗುತ್ತೆ? ಈಗ ಆಲ್ರೆಡಿ ಎವಿಡೆನ್ಸ್ ಕಮೆಂಟ್ಸ್ ಆಗಿದೆ. ನೋ ಅರ್ಜೆನ್ಸಿ ಕೌನ್ಸಿಲ್ ಲೆಟ್ ಇಟ್ ಕಮ್ ಆಸ್ ಪರ್ ರೋಸ್ಟರ್. ಕಂಪ್ಲೈ ಆಗಿದ್ದೆಲ್ಲ ಆಸ್ ಪರ್ ರೋಸ್ಟರ್ ಆಯ್ತು. ಎವಿಡೆನ್ಸ್ ಕಮೆಂಟ್ಸ್ ಆಗಿದೆ. ವಾಟ್ ಇಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ? Maybe it is reduced by mistake. Correction. Third document. Already disposed of. ತಗೊಳ್ಳಿ ಅದೇನು ನೋಡಿ ಯಾಕೆ IPR earlier, I think, madam, earlier I was sitting in IPR also. Earlier MFA mostly probably 2021. IPR subject was also there. Noted here. Wait ಮಾಡಿ counsel. Page wise ಕರೆಸ್ತೀವಿ mention ಮಾಡಿ ಅವಾಗ. Serial number 18, page number 4. 19 to 24. 22 ಹೇಳಿ ಕೌನ್ಸಿಲ್ ಏನಾಗ್ತದೆ? Last time your colleague was there while arguing, but I am not taking up this matter. Let this matter go before some other bench. My brother's son is working with him. He also signed wakalat. That's why while reading the papers, I found his signature also, not before me. I thought not before me, madam. 22, serial number 22. Like I am not taking up this matter, counsel. I have verified the wakalat. My brother's son has signed the wakalat. It is not fair on my part. I may take the oath, but I should not give rumors to anybody, comment about me. That's why I am not taking up this matter. But even my wife comes and argues matter, I will hear. But I should give any rumor for the bar that though I pass an order on merits, it may give different colors. That's why I will not. Though I took both, not before me. Not before me, Madi. Post the matter before the other roster bench. Not before me ಮಾಡಿ post the same Monday na ಹೋಗಿ ನೀವು ಅಷ್ಟೊಳ್ಳೆ ನಿಮ್ ಟೈಮ್ ಸಿಗುತ್ತೆ ಇವತ್ತು ಫ್ರೈಡೆ. ನೋ ಕೌನ್ಸಿಲ್ ಆಲ್ರೆಡಿ ಪಾರ್ಟೆಡ್ ಆಕ್ಚುಲಿ ಅಂತ ಮಾಡಿಲ್ಲ ನಾನು. ಹರ್ಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಮಾಡಿದ್ದೀನಿ. ಆಯ್ತು ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕಿ ಡೇಟ್ ಕೊಡಿ. ಟ್ಯೂಸ್ಡೇ ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 22 26 ಹಾಕಿ 26 Tuesday instead of Monday, Tuesday. ಬೇಕಾಗುತ್ತಾ? ಆಯ್ತು, ಈಗಲೇ ಕಳ್ಸ್ಕೊಡಿ, ಫೈಲ್ ಹೋಗ್ಲಿ. ನಾಳೆ ವರ್ಕಿಂಗ್ ಅಲ್ವಾ? ಇವತ್ತೇ ಕಳ್ಸ್ಕೊಡಿ, ಫಸ್ಟೇ ಕಳ್ಸ್ಕೊಡಿ ಮೇಡಮ್. 26th Tuesday. ಯಾವಾಗ್ರಿ? 20th ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ. ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ 25 to 30. ಯಾರು ಬಿಸಿ? 28. ಲಾಸ್ಟ್ ಟೈಮ್ ಎಲ್ಲ ಬಂದಿದೆಯಲ್ಲ, 1 and 2 ಡಿಸ್ಮಿಸ್ಡ್. ಅದರ್ ಸೈಡ್ ಯಾರು? ದಯಾನಂದ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಿ? ಕೌನ್ಸಿಲ್ appearing for the applied 6 time and council also submits that already informed. Both the councils are respond number 1 and 2. Entry ಮಾಡಿರೋ ಇದೆಯಾ ಏನು entry ಮಾಡಿರಲಿಲ್ಲ ಆಯ್ತು council submits that already informed other side and hence list this matter Monday ಗೆಲ್ಲ dates ಇಲ್ಲ date ಕೊಡಿ next 37 serial number 30 yes madam did you inform other side after 14th July. Date. What is the next date of hearing? Orders. Council for the applied 6 time and council respondent also submits that already an application is filed on the orders on 11 and the same is reserved for orders on 14th July. And hence this interim order granted earlier is extended. This matter after 14th pudding. 17/7. 31 to 35.
My lord, serial number 33.
ಯಾವ್ದ್ರಿ
serial number 33 my lord.
ಗೊತ್ತಾಗಲ್ಲ ನಿಮ್ serial number 41 1 second council wait 41 ಏನ್ ವಿಜಯಶೇಖರ್ ಗೌಡ ಅಂಡ್ ಸರ್ವೂಡ್ ಅಷ್ಟೇನಾ ತಗೊಳ್ಳಿ petitioner council 6 time list this matter 1 week 37 serial number
33 my lord.
ಹೇಳಿ council ಏನಾಗಬೇಕು
Need a week's time for additional documents to produce my lord.
last time also senior council took time M ಶಿವಪ್ರಕಾಶ್ ಹೌದಾ
ಹೌದು
33 M ಶಿವಪ್ರಕಾಶ್
ಹೌದು my lord.
ನಾನು ಆರ್ಡರ್ ಶೀಟ್ ನೋಟ್ ಬರ್ಕೊ ಬಂದಿದ್ದೀನಿ ನೋ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ appellant council only sought time in the earlier occasion also
My lord, ಅದು ಪಾರ್ಟಿಷನ್ ಡೇಟ್ ಸೂಟ್ ಹಾಕ್ಬೇಕಿತ್ತು ನಮ್ಗೆ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇಂದ ಆಗ್ಲಿಲ್ಲ.
ಸೂಟ್ ಪಾರ್ಟಿಷನ್ ಹಾಕಿ ಬೇರೆದಕ್ಕೂ ಹಾಕಿ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಪಾರ್ಟಿಷನ್ ಡೇಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕ್ಬೇಕಿತ್ತು my lord, ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕ್ಬೇಕಿತ್ತು.
ಕೌನ್ಸಿಲ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದು ಆಯ್ತು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು ಇಲ್ಲ ಕೊಡಿ. serial number 33 appellant counsel seeks time again to produce the documents and hence this matter on 37. Yes madam ಹೇಳಿ. other side ಸತೀಶ್ ಚಂದ್ರ ಕೆವಿ ಮಾಡಿ ರೀಚ್ ಆದ್ಮೇಲೆ ಬಂದು ಮೆನ್ಷನ್ ಮಾಡಿ 2016 ಮ್ಯಾಟರ್ CRP ಬಹಳ ದಿವಸದಿಂದ ಇರಲಿಲ್ಲ. Revision petition is allowed. The order of the trial court dated 7/3/23 passed on IA 1 in SC number 1512 of 5 of 22 is set aside. The application filed by the learned counsel for the petitioner defendant number 3 under order 7 to 11 of CPC is allowed. The respondent is given liberty to approach the court under the Karnataka Rent Act. Appeal is allowed. Impugned judgment and decree passed by the first appellate court in RA number 4 of 2004 dated 21/3/2007 is set aside and consequently suit in OS number 160 of 1999 is dismissed. The appeal is dismissed. ಯಾವ್ದೋ ನಿಮ್ಮಾನ್ಸ್ಗೆನ ಕರ್ಕೊ ಹೋಗ್ಬೇಕು ಅಂದ್ರಲ್ಲ ಆಯ್ತಾ ಟ್ರೀಟ್ಮೆಂಟ್ ಆಯ್ತಾ ನಿಮ್ಮಾನ್ಸ್ ಅಲ್ಲಿ ಯಾವ ಕೊಡ್ತಾರ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ ಏನ್ ಅರೇಂಜ್ ಆಗ್ಬೇಕು ಮೀಟಿಂಗ್ ಬೋರ್ಡ್ ರಿಪೋರ್ಟ್ ಯಾವಾಗ ಒಂದ್ ವಾರ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ Council, the HCP 6 time, list this matter on, Madam Director. 21/6. 21/6. R3 to 6. 3 to 6 ನೀವು appear ಆಗ್ತೀರಾ? ಈಗ ನಾವು you are taking ಈಗ 3 to 7 ನೀವು ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ತೀರಾ? ಹಾಕಿದ್ರಿ ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಸಮೀರ್ SN undertakes to file wakalat for R3 to R6. Copies also Saruda ಕೊಟ್ಟಿದ್ದೀರಿ. The council Sri Samir SN submits that he has already received the copies of CRP. And hence, list this matter shorted ಬೇಕಾ? ಯಾವಾಗ ವಕಾಲತಕ್ಕೆ list this matter on 3/7. Awaiting service of notice to R2 and R3. ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿರುತ್ತೆ ನೋಡಿ ಮೇಡಮ್. ನಾನ್ ಟೇಕಿಂಗ್ ಆಫ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಕಾಪಿ ಫಾರ್ ದಿ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಪಿಟಿಷನರ್. ಯಾಕೆ ತಗೊಳ್ಳಿಲ್ವಾ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್? 1/6 ಅಂತಂದ್ರೆ 3/7. Await notice of R2 and R3. 3/7. On arraying of D1 to D19 as parties to CRP. Copies. Note ಹಾಕಿದ್ರಿ ಏನದ್ ನೋಟ್? ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ನೋಟ್ ಹಾಕಿದಿರಿ. ಕೌನ್ಸಿಲ್ ನೋಟ್ with regard to not making other defendants that they are neither aggrieved nor parties to the IA filed by the petitioner, and hence council submission is accepted. Post the matter for admission on ಯಾವಾಗ date as per roster ಯಾವಾಗ ಬರುತ್ತಾ roster 3-4 days ಅಲ್ಲ. Compliance of office objection raised after compliance made by the council. ಹೇಳ್ರಿ after compliance made ಮತ್ತೇನ ಸಮ್ಮರ್ ಹಾಕ್ಬಿಟ್ಕೊಡಿ. ಎಷ್ಟು ದಿವಸ ಬೇಕು? Council 6 1 week time, and hence 1 week time granted. Next, maintainability petition window of section. ಹೇಳಿ. ಅರೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರಲ್ಲ ಏನೋ ಮೇಂಟೈನಬಲ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ತೀನಿ ನಿಂದಿದ್ರು. ಕನ್ವರ್ಟ್ ದಿ ಸೇಮ್ ಸಿವಿಲ್ ರೇಜ್ ಪಿಟಿಷನ್ ರಿಟ್ ಪಿಟಿಷನ್ ಆಗಲ್ಲ ಸರಿ. ಕಮರ್ಷಿಯಲ್ ಅಪೀಲ್ ಏನೋ ಆತರ ಏನೋ ಬರುತ್ತೆ ಅನ್ಸುತ್ತೆ. ಆಯ್ತು ನನಗೇನಿಲ್ಲ, ನೀವ್ ಏನ್ ಕೇಳ್ತೀರೋ ಪರ್ಮಿಟ್ ಮಾಡ್ತೀನಿ ತಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರಿವಿಷನ್ ಪಿಟಿಷನರ್ has filed memo seeking permission to convert the instant civil revision petition to a writ petition. All objections ಹಾಕ್ತಾರೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ದೆ. And hence permitted to convert the same as writ petition as sought in the memo.
My lord, I appear for the
And for the statistical purpose, it was disposed of. CRP, yes, madam. Serial number 10.
for the petitioner, my lord. I may be permitted to convert of commercial appeal, my lord.
The council orally praised this court to permit the revision petitioner to convert the same as commercial appeal. And hence permitted to convert the same as commercial appeal. And for the statistical purpose, CRP is disposed of.
Much obliged.
Again, office objection in necessary DCF to be made good. ಆಯ್ತು, ಈಗ ಏನ್ ಹಾಕಿದಿರಿ ನೀವು? ಅಲ್ಲಿ ಕೊಟ್ಟು ಏನ್ ಕೊಟ್ಟಿದ್ರಿ ಅದ್ ಕೊಡ್ಬೇಕು. Value of the appeal to be stated along with palladium and 12% additional market value ಏನು ಮಾಡಿ ಸುಮಾರಿದೆ ನೋಡಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. On hearing the learned counsel for the appellant leaving open the office objection for consideration on service of notice to the respondents, emergent notice is issued to the respondents, returnable by 3 weeks. The counsel open for the appellant shall furnish requisites for issuance of such notice forthwith ಅಂತಿದೆ. PF ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು? ಆಗಿದೆಯಲ್ಲ, ಇದು ಕೆಪ್ಟ್ ಓಪನ್ ಅಂತ ಮಾಡಿದಾರಲ್ಲ ಮತ್ತೆ. ಮೋಸ್ಟ್ಲಿ ಇದು ಎಸ್ಟೇಟ್ ಆಫೀಸರ್ ಅಂತಂದ್ರೆ HCGP ಬರ್ತಾರೆ ಮೇಡಮ್. ಮೋಸ್ಟ್ಲಿ ಮೇಡಮ್ ನ್ಯಾಷನಲ್ ಹೈವೇ ಬೇರೆ ಕೌನ್ಸಿಲ್ ಮೇಡಮ್. ಗೌರ್ಮೆಂಟ್ ಸ್ವಲ್ಪ ಎಚ್ಚರಾಗಿರ್ಬೇಕು ಗೌರ್ಮೆಂಟ್. ನಿಮಗೆ ಬರುತ್ತಾ ನ್ಯಾಷನಲ್ ಹೈವೇ ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಬರ್ತಾರ? ನ್ಯಾಷನಲ್ ಹೈವೇ ನೋಡಿ ಬೇರೆಯವ್ರು ಬರ್ತಾರೆ. ಯಾಕೆ ನ್ಯಾಷನಲ್ ಹೈವೇ ಯಾರು ಕೌನ್ಸಿಲ್ ಇದಾರ? ಯಾರು ನೋಡಿ ವೆರಿಫೈ ಮಾಡಿ ನೋಡಿ. ಅವ್ರಿಗೆ ಡೈರೆಕ್ಟ್ ಮಾಡೋಣ. ಅವ್ರ ಪ್ಯಾನಲ್ ಇದಾರ, NHA ನಲ್ಲಿ ಪ್ಯಾನಲ್ ಇದಾರ ಅವರು. ಆಯ್ತು. ಏನ್ ಹಂಗೆ ಹೆಂಗ್ ಡೈರೆಕ್ಷನ್? ಅದೇನ್ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು, ಈಗ ಯಾರು ಅಂತ ಕೊಡ್ಬೇಕಲ್ಲ. ಈಗ ಆಲ್ರೆಡಿ ಇಟ್ ವಾಸ್ ಸರ್ವ್ಡ್. ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಅಂಡ್ ಎಸ್ಟೇಟ್ ಆಫೀಸರ್ ಸರ್ವ್ಡ್ ಅಂತಿದೆ. ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಆಲ್ಸೋ. ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ನೀವು ಬರ್ತೀರ. HCGP is directed to take notice for art, but NHA ನಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಇರ್ಬೋದು. ನಿಮಗೆ ಬರಲ್ಲ ಅನ್ಸುತ್ತೆ. ಆಯ್ತು. ದಿ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ for NHA is directed to take notice and file MA within 2 weeks. ಬರ್ಲಿ, ನಿಮ್ ನೋಡೋಣ ಕೆಪ್ಟ್ ಓಪನ್ ಅಂತಿದೆ, ಅವರು ಬರ್ಲಿ. List up to 2 weeks. Narayan MS non-compliance of office objections. ಸೆಕೆಂಡ್ ಟೈಮ್ ಅಂತ ಬಂದಿದೆ ನೋಡ್ರಿ. ಇನ್ನು ಎಷ್ಟಿದೆ ಮೇಡಮ್ ನೋಡಿ? 11 ಇತ್ತು, ಇನ್ನು 4 ಉಳಿದಿದೆ ಅಂತ. ಆಯ್ತು. ಎಷ್ಟು? Council seeks 1 week time to comply remaining office objections and hence granted. MK Shura maintain of the appeal against the order dated 1/4/23. ಇಟ್ಟು ಕನ್ವರ್ಟ್ ಮಾಡ್ಬೇಕಾ? ಮೆಮೊ ಕೊಡ್ತೀರಾ? ಓರಲ್ ಸಬ್ಮಿಷನ್ ನೋಡಿ. The counsel appearing for the appellant files memo seeking permission to convert the same as writ petition. ಏನ್ ಮಿಸ್ ಇದು? ಆಯ್ತು. And hence permitted to convert the same as writ petition. And for the statistical purpose, the same is disposed of. Memo kodi. RPFC. The registry is also directed to return the certified copies to the petitioner. Petitioner counsel. Heard in part 10 the Ajit PP as Manoj Kumar. Some of citations and affidavit filed. Henry. Why? ಏನು ಇದು ಏನು ಸ್ಟೇಗ? ಲಿಫ್ಟ್ ದೇನ್ರಿ? ಏನ ಕೊಡ್ತಿದ್ರಲ್ಲ ಫೋಟೋಗ್ರಾಫ್ ಡ್ಯಾಮೇಜ್ ಮಾಡಿರೋದು. ಮೂರನೇ ಸರಿ ಇದು ಲಿಸ್ಟ್ ಆಗಿರೋದು ಪಾರ್ಟ್ 2. The counsel appearing with respondent seeks time on the ground of medical emergency, medical exigency of the respondent. Hence, list this matter on 22nd or 23rd. I have 23rd. A3 for 23 for appointment guardian for deceased LRs of R1 returned with office objection. ಏನ್ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ನೋಡ್ರಿ, ಹಾಕಿರ್ತಾರೆ ನೀವು. ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ನೋಡಿ. ಇದು ಬ್ರಿಂಗಿಂಗ್ LRs ಆಫ್ ಡಿಸೀಸ್ R1 ಅಂದ್ರೆ ಅದೇ ಅವ್ರೇನಾ? ಕಾಪಿ ಕೊಡಿ ಅವರಿಗೆ, ಯಾರ್ಯಾರು ಅಂತ ಹಾಕೊಟ್ಟು ಒಂದು ಕಾಪೀಸ್ ಕೊಡಿ ಅವರಿಗೆ ನೋಡಿ. ದಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಅಪೆಲೆಂಟ್ ಸೀಕ್ಸ್ ಟೈಮ್ ಟು ಕೌನ್ಸಿಲ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಫರ್ನಿಶ್ ದಿ ಕಾಪಿ ಆಫ್ IA ನಂಬರ್ 1 of 23, 2 of 23, 3 of 23 to council. ನೀವು ಗೆವೇಟ್ ಈಗ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ವಾ? ಆಯ್ತು, ನೀವೇ ವೆರಿಫೈ ಮಾಡಿ ಹೇಳ್ತೀರಾ? ಯಾಕೆಂದ್ರೆ ಈಗ ನಿಮ್ಗೆ ವಕಾಲತ್ ಸೀಸ್ ಆಗ್ಬಿಡುತ್ತೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ತೀರ್ಕೊಂಡ ತಕ್ಷಣ ನಿಮ್ ವಕಾಲತ್ ಸೀಸ್ ಆಗುತ್ತೆ, ನಿಮಗೆ ಕಾಪೀಸ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಇಫ್ ಯು ಆರ್ ರೆಪ್ರೆಸೆಂಟಿಂಗ್ ದಿ LRs, ನಿಮ್ಮ ಹತ್ರ ಬಂದಿದ್ರ? ಅವರು ಬಂದಿಲ್ಲ. ಅಲ್ಲೂ ಮೆಮೊ ಹಾಕಿದ್ರೆ ನಂಬರ್ 3 ದಿನ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಳ್ಳಿ. ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಕಂಪ್ಲೈ ವಿತ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆನ್ IA ನಂಬರ್ 3 of 23. What is this matter? ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 26 NR ಕೃಷ್ಣಪ್ಪ. Extension of time for depositing arrears of maintenance filed by advocate for petitioner. Deposit ಮಾಡಿದಿರಿ. Non filing of acknowledgement for having paid maintenance and litigation expenses by the advocate. The counsel appearing for the petitioner files memo along with copy of deposit receipt and deposit receipt for having deposited an amount of rupees 20,000 for having deposited an amount of rupees 70,000 and also 20,000. ಈಗ ಮತ್ತೆ IA 3/22 become infructuous ಅಲ್ಲ, ನೀವು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಕೇಳಿದಿರಿ. ಈಗ ಆಲ್ರೆಡಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಫಾರ್ ಡೆಪಾಸಿಟಿಂಗ್ ಅರಿಯರ್ಸ್ ಆಫ್ ಮೇಂಟೆನೆನ್ಸ್ ಅಂತ ಬರ್ದು ಹಾಕಿದಿರಿ. ಏನಿದು ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಿ. ಅಂಡ್ ಇನ್ ವ್ಯೂ ಆಫ್ ಪೇಮೆಂಟ್ IA ನಂಬರ್ 3/22 ಬಿಕಮ್ ಇನ್ಫ್ರಕ್ಶಿಯಸ್. ಏನ್ರಿ ನೋಡ್ತೀರಾ? ಇನ್ನೇನೋ ಡ್ಯೂ ಇದೆಯಾ ನೋಡ್ಕೊಳ್ಳಿ. ಅಲ್ಲ, ಅರ್ಲಿಯರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಅಂದ್ರೆ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಇತ್ತ ಡೆಪಾಸಿಟ್ ಮಾಡಿ. ಡೆಪಾಸಿಟೆಡ್ ಒಂದ್ ತಿಂಗ್ ಆದ್ಮೇಲೆ ಮಾಡಿದಿರಿ, ಅಲ್ಲಿ ತಗೊಂಡ್ರ? ಆಯ್ತು ತಗೊಳ್ಳಿ. ಏನಾಯ್ತು ಮೇಡಮ್? the IA become infructuous. Arrears will be deposited before the family court Mysore within 30 days from today, calculating arrears at rupees 5,000 per month. IA 2 stands disposed of accordingly. So the counsel for the respondent ಅಲ್ಲ ಅದನ್ನ ಹಂಗೆ ಪೆಂಡಿಂಗ್ ಇಟ್ಟಿರಿ. IA ನಂಬರ್ 3 ಫಾರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ಗೆ ಡಿಸ್ಪೋಸ್ ಮಾಡೋದ್ ಬೇಡ, ಇನ್ಫ್ರಕ್ಚುಯಸ್ ಮಾಡೋದ್ ಬೇಡ. ಅಂಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ವೆರಿಫೈ whether the amount is deposited as directed by this court order dated 15/3/22. It the order 5,000 ರೂಪಾಯಿ ಪ್ರಕಾರ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರ ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಹೇಳಿ. ಬಟ್ ಕಟ್ಟಿದ್ರೆ it becomes infructuous. List this matter on 26/6. Addition. ठीक है. ಅದರ್ ಸೈಡ್ ಇಲ್ವಾ? ಗಿರೀಶ್ ಬಿ ಬಳದಾರೆ. ಪಾಸ್ ಓವರ್ ಏನ್ರಿ MA ಅಲೋ ಮಾಡಿದ್ದಾರೆ. ರಿಟರ್ನ್ ಆಫ್ ಕ್ಲೈಂಟ್ ಸೆಟ್ ಅಸೈಡ್ ಪ್ರಿಲಿಮಿನರಿ ಇಶ್ಯೂ ಆಯ್ತು ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಕೆ.ವಿ. ನರಸಿಂಹಣ್ಣ, ಅಜಯ್ ಪ್ರಭು ಅಂಡರ್ಟೇಕ್ಸ್ ಟು ಫೈಲ್ ವಕಾಲತ್ ಫಾರ್ R4 and R5. ಹೌದಾ? ಎಷ್ಟು ಯಾವಾಗ ಹಾಕ್ತೀರಿ ವಕಾಲತ್? ಎಲ್ಲರೂ ಇದೆ ಸರ್, ಇಟ್ ವಾಸ್ ಸರ್ವ್ಡ್ ಲಾಂಗ್ ಬ್ಯಾಕ್. ಇಲ್ಲಿವರೆಗೂ ಯಾಕೆ ಮಾಡಿಲ್ಲ? 26 ಆಗ್ಬೋದಾ? 29 ಬೇಕಾ? ಹಾ, 29 ರಜಾ ಹಬ್ಬ ಇದೆ ನೋಡಿ ಅವತ್ತೇನು ಬಕ್ರೀದ್. 30th ಫ್ರೈಡೆ, 30th ಆಗ್ಬೋದಾ? 30th 2 ವಾರ ಆಗುತ್ತಲ್ರಿ ನಿಮ್ಗೇನ ಇಲ್ವಲ್ಲ? ಲಿಸ್ಟ್ ಇಸ್ ಮ್ಯಾಟರ್ ಆನ್ 30th. 36 ದೇವೇಂದ್ರ ಗೌಡ RR ಟ್ರಾನ್ಸ್ಫರ್ ಪಿಟಿಷನ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ಡ್. ಹೇಳ್ರಿ ಸುಚೇತಾ ಮುಜುಮ್ದಾರ್. ಹ್ಮ್. ಹಾ ಹಾ
One suit is already transferred under their consent.
ಹಾ
My suit is a declaration of loss of possession.
Hmm.
The other 4 suits are pending before CCS 58. But those suits, those dependents also parties in my suit. Those writings are dependents in those suits are distributed property in my suit. But very same property.
Properties are same.
Parties are same.
Huh?
Parties are same.
Parties are same, but properties are same.
That they are saying that it is property that 80
Wait, madam.
for 8 years. Okay. Now 82/2.
Hmm.
So they admit that their property is.
Maybe number may be different, but area sides.
ನಮ್ಮ ಲ್ಯಾಂಡ್ ಅಲ್ಲೇ ಅವ್ರ ಸೈಟ್ ಇರೋದು.
ಹಾ
82/8 ಅಂತ ಅವರು ಕಡೆಯಿಂದ ಜಯಮಾನ್ ಅವ್ರ ಕಡೆಯಿಂದ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು.
ಆಯ್ತು.
They came at spot in my property. That is 82/2.
Original survey number is 82/2.
My survey number. In fact, I have made all the properties as scheduled properties. 82/2 is A schedule. 82/8A, 82/2 8A, 82/8A. That is exclusive to property. And whatever sites they are claiming is scheduled property. Their scheduled property is scheduled property in my suit. I am asking for possession of that particular scheduled property. That is injunction suit. And they themselves have consented for transfer of one suit. When it comes to the other suit, they are objecting. I don't know what is the reason. That is the reason I have filed application for the honorable principal district judge for transfer of the suit. That was rejected on the technical ground and different cause of action you cannot be. Obviously, cause of action will be different in injunction suit and mine is particular resident. And since the property dispute is there, if they succeed in injunction suit, ಮತ್ತೆ ನಾನು ಅದನ್ನು ಸೆಟಸರಿ ಕೇಳಬೇಕಾಗುತ್ತೆ. All the suits are in stage of evidence now. My suit is also for evidence and their suit is also for evidence. I'm looking for in order to avoid a contradictory orders being passed in that and so that common evidence can be laid. And even the other defendants also there in their suit of loss as well is my suit. In fact, in miscellaneous petition I have narrated all the facts.
But in both the suits are parties are same.
They are defendants. In addition to that, other defendants are there, some of the defendants. Secondly, now out of 20 sides, they have injunction suit being filed by only 5 parties. In fact, I have filed suit against all the 20 sites in non-case. That is all the difference. These 5 sites, including 5 sites, were filed injunction suit. And also the other 15 site owners, I have made as parties. And other than that, there is no difference. ಅಷ್ಟುವೇಲ್ ಅವರು ಅಷ್ಟುವೇಲ್ ಅನ್ನೋರು ಅವರು ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ, ನಾನು ಪಾರ್ಟಿ, ನನ್ನ ಮಾರಿರೋ ನಾನು ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀನಿ, ಅವರು ಪಾರ್ಟಿ. That is all the difference. No, they have to tell you the parties are different.
Action is different and plan of different. Because we have higher teaching directly. The corporate action arrow is when I file a case, they have different in my position.
Even different cause of action also will not come in the way of transferring the case to one court. But other grounds, what are the other grounds? You are seeking the relief of permanent injunction. Ah. Hmm. According to you, those sites are carved out of which survey number? 82 bar? What is your number? 8A. 8A is carved out of which survey number, madam? 82, 8A is the survey number. 8A is also the survey number.
Rescheduled property, Mysore.
They have HTBC property.
Rescheduled ಅಂತ ಮಾಡಿದ್ದೀರಿ. ಇವಾಗ site ನ rescheduled ಅಂತ ಮಾಡಿದ್ದೀರಿ. Sites ನ rescheduled ಅಂತ ಮಾಡಿದ್ದೀರಿ.
Right. On what basis you are claiming 82A? 82 8A.
Claim ಮಾಡ್ತಾರೆ.
Our claim ಮಾಡದ್ ಬೇಡ, ಪ್ರಾಪರ್ಟಿ is in existence.
They have obtained state
ನಿಮ್ ಸರ್ವೆ ನಂಬರ್ ಯಾವ್ದ್ರಿ? ನೀವು ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿಗೆ 82/2 ಹೌದಲ್ಲ? ಈಗ 82/8 ಏನು ಒಂದ್ ಸಪರೇಟ್ ಸರ್ವೆ ನಂಬರ್ ಇದೆಯಾ? ಮತ್ ಸಪರೇಟ್ ಸರ್ವೆ ನಂಬರ್ ಇದ್ರೆ ಹೌ ದೇ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಡಿಸೈಡ್ ಇಶ್ಯೂ. Those properties are different properties. You are not claiming that survey number 82/8A which is shown is out of survey number 82/2.
82/8A ಅಂತ ಜಯಮ್ಮ ಕಡೆಯಿಂದ ಡೆಲಿಗೇಟ್ ಮಾಡ್ಕೊಂಡು 82/2 ನ ಕೂತ್ಕೊಂಡಿದ್ದಾರೆ. ಸೈಟ್ ಅಲ್ಲೇ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅಲ್ಲಿ ಸೈಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. 82/2 ನಲ್ಲಿ ಬಂದು ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ. That is my clear pleading before the honorable. ಹಾಗಾಗಿ ಅದು ಎರಡು ಸರ್ವೆ ನಂಬರ್ ನಾನು ಎ ಶೆಡ್ಯೂಲ್ ಬಿ ಶೆಡ್ಯೂಲ್ ಮಾಡಿದ್ದೀನಿ. ಅವ್ರ ಸೈಟ್ಸ್ ಸಿ ಶೆಡ್ಯೂಲ್ ಮಾಡಿದ್ದೀನಿ. ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಎಲ್ಲಿ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಾಗತ್ತೆ.
How they have to mention the GDP property in the respect of 82/2.
That's why the trial court also comes to the conclusion that the properties are different. The counsel for respond number 1. If you are claiming right in respect of 82/8A also, that is not your claim. Your claim is only in respect of 82/2 only. I say 82/8A is different survey number. Why the cases are to be clubbed? You are not claiming ownership in respect of 82/8A. ಹೌದಾ? ಆಯ್ತು, ಬರೋದಿಲ್ಲ. ನೀವು ನಿಮ್ ಕೇಸ್ ಅಲ್ಲಿ ಡಿಕ್ಲರೇಷನ್ ಸೂಟಲ್ ಪ್ರೂವ್ ಮಾಡಿ ಅಷ್ಟೇ. That's all. Why case has to be transferred to the one court? ಅವ್ರದ್ದು ಡಿಗ್ರಿ ಆದ್ರೂ ಅವ್ರದ್ದು ಓನ್ಲಿ 82/8A ಮಾತ್ರ ಡಿಗ್ರಿ ಆಗುತ್ತೆ. ನಿಮ್ದಕ್ಕೆ 82/2 ಡಿಗ್ರಿ ಆಗಲ್ಲ. ನೀವು ಪೊಸಿಷನ್ ಕೇಳಿ, ನಿಮ್ಮಲ್ಲಿ ನೀವು ಪ್ರೂವ್ ಮಾಡಿ ಫಸ್ಟ್. 82/2 ನಲ್ಲಿ they are squatting on the property ಅಂತ. You prove the title as well as the possession. ಆಯ್ತು, ನಾನು if the property is one and the same ಆದ್ರೆ it's okay. We can transfer the case to one court and decide the issue. But here the property is different. 82/2, you are also not disputing separate property, and 82/8A is also a separate property. When the separate numbers, separate survey numbers are there, how the court can order for club both the cases and try together?
Because parties are same.
Parties may be. Their suit is only for permanent injunction between their vendor and also them.
Another party.
Party matter, because now you are claiming that they claim. Now then you cannot prove 82/8A belongs to you.
82/8A ನಮ್ದಲ್ಲ.
I told the petitioner counsel and also the counsel appearing for the respondent. This revision petition is filed, challenging the order passed by the trial court in rejecting the application filed under section 24 of CPC. Transfer the case to one court, since cases are pending before CCS 29 and CCS 58. And same was rejected. ರಿಜೆಕ್ಟೆಡ್ ಬಂತ ಮೊದಲೇ ಹೇಳಿದ್ನ ಚಾಲೆಂಜಿಂಗ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ರಿಜೆಕ್ಷನ್ ಆಫ್ ಅಂತ
In the application.
rejection certificate. The counsel appearing for the revision petitioner would vehemently contend that the trial court has committed an error in dismissing the said application. The counsel would vehemently contend that he has filed the suit for declaration and possession in respect of survey number 82/2. And also counsel would submit that survey number 82/2 is mentioned as A schedule in his suit. And in the very same suit, he has also made a B schedule property, which is 82/8A. And also in C schedule, the property of the respondent is shown in respect of the particular site which the respondent has purchased. And all the matters has to be tried together in one court, and hence sought for the transfer of the case to quota number pending. Quota number 29, where the suit filed by the appellant is pending, and other suits are pending in quota number 58. The court below has committed an error in rejecting the application and fails to take note of the fact that the appellant is also claiming the relief of possession, since the respondent is squatting on the property belongs to the appellant herein. Counsel appearing for the respondent would vehemently contend that the property which the appellant is claiming is in respect of survey number 82/2, and the respondent is has purchased the property in respect of survey number 82/8A. And no dispute with regard to the fact that there are two survey numbers 82/2 and also 82/8A, and both are not one and the same. The trial court, having considered the said fact into consideration, comes to the conclusion that both the properties are different, and hence the other case suits cannot be transferred to the particular court, and hence not committed any error. Having heard the respective counsel and also on perusal of material, no dispute with regard to the fact that the appellant has filed the suit seeking the relief of declaration and for possession in respect of survey number 82/2, and also no dispute with regard to the fact that survey number 82/8A is also shown as B schedule, and the property which is purchased by the respondent is also shown as C schedule property. The trial court, having considered the grounds urged in the petition as well as contention of the respondent, comes to the conclusion that both the properties are different, and hence question of transferring the other suit in respect of suits are filed in respect of survey number 82/8A cannot be decided in one court. No dispute with regard to the fact that both the survey numbers are different. That is, plaintiff claiming in respect of survey number 82/2, and defendants are claiming and the respondent is claiming in respect of service site carved out of in survey number 82/8A. The counsel for the appellant also not disputes the fact that other survey number 82/8A is also a separate property. When both properties are distinct properties, in the very same court, all the suits cannot be decided, and hence I do not find any error committed by the trial court when the properties are different, totally different. And the same is also not in dispute, and the suits are also in different stages, and also the other suit is filed for only for the relief of permanent injunction by the respondent in respect of the site which has been purchased out of survey number the site which is carved out of survey number 82/8A, and not in respect of survey number 82/2, and hence I do not find any merit in the revision petition to set aside the order of the trial court. Of the discussions made up, I pass the following order. The observation made by this court shall not be influenced to the shall not be influenced to the trial court in both the suits. Liberty was given after the final disposal of OS anta. ಅದೇನೋ ಬರ್ಲಿಕ್ಕೆ ಮೊನ್ನೆ ಆರ್ಡರ್ ಮಾಡಿದ್ವಲ್ಲ. ಅದು ಬಂದಿದೆಯಾ? ಇದರಲ್ಲಿ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಲ್ಲ, ಯಾರು ಫೈಲ್ ಮಾಡಿರೋದು ಇದು? ಆಯ್ತು, ಇನ್ ದ ಮೀನ್ ವೈಲ್ ಯು ಕಂಪ್ಲೈ, ಯು ಟೇಕ್ ನೋಟಿಸ್. ಇದ್ರಲ್ಲಿ ನೀವು ಪಾರ್ಟಿ ಇದ್ದೀರಾ? ಡೈರೆಕ್ಟ್ ಮಾಡ್ತೀನಿ, ನೀವು ಪಾರ್ಟಿ ಇದ್ದೀರಾ ಇದ್ರಲ್ಲಿ? ಕಾಪಿ ಕೊಡಿ. ಸೇಮ್ ಪಾರ್ಟಿ ಸರ್, ಹೌದಾ? ತೊಗೊಳ್ಳಿ. ದಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ revision petitioner in 52 of 22 is directed to serve the copy of this revision petition to the council Sri Kamaluddin forthwith, and also directed to comply with other office objections forthwith. List this matter. ಇವತ್ತು ಕೊಡಿ ಕಾಪಿ. ಯಾವತ್ತು? ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ ಮೇಡಮ್. 26/6. ಇದು ನಾಟ್ ಬಿಫೋರ್ ಮೀ, ಪ್ಲೇಸ್ ಬಿಫೋರ್ ದಿ. ಆಯ್ತಾ ಮೇಡಮ್? ಸೀರಿಯಲ್ ನಂಬರ್ 22 ಆಯ್ತಲ್ಲ? ಸರಿ. ಯಾವುದು? ಅದು ಎರಡು ಇದೆಯಲ್ಲ, ಎರಡು ಒಟ್ಟಿಗೆ ಮಾಡಿದ್ವಿ. ಅದು ಎರಡು ಒಟ್ಟಿಗೆ ಬರುತ್ತೆ. ಅವತ್ತು ಒಟ್ಟಿಗೆ ಡಿಸೈಡ್ ಮಾಡೋಣ. 26/6 ಅದು.
Lord, I appeal for the respondent.
Order 7 rule 11A and D ಏನ್ರಿ ಇದು? ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Third party, stranger to a compromise. When say food, challenging the compromise. Is a totally stranger. So
He is not a party to the compromise.
not a party to compromise. So the petitioner hearing and when the suit against the court respondent is the subject. Thereafter, a compromise was entered into between the petitioner and the society. So thereafter, the compromise, they preferred an application. 22 here before the same court. So that was rejected. So against that, a petition was filed before this honorable court. That petition also got dismissed. Thereafter, a suit is filed. In the suit, the player sought is to pay. It's like that the compromise entered into by the first defendant, the defendant to life on 22/17 in OS 360 and that the consequential order dated 22/17 and that the compromise is passed by the court of the honorable Assistant Senior Citizen General in OS 360 that is defendant to life are not binding in the society first defendant and its members and vitiated by fraud led by defendant going to life. Now the plaintiff is not seeking any relief. They are not accused of the compromise decree in any way. So there is sought, seeing that here the court respondent society is telling that yes, they are going by decree. In fact, statement was also made to the petitioner in the decree. So what had happened is the court respondent society had entered into an agreement with them for 10 acres of land. They found their layout in 14 acres and got regularized. We filed a suit challenging the entire layout itself. So keeping the welfare of the members of the society, compromise was entered where the society agreed to pay a sum of
In the respect of 4 acres of land which also formed as layout and made the payment.
paid for the
Right.
agreed to pay the payment. So 60 lakhs on the date of compromise, 50 lakhs was paid. Thereafter, totally a sum of 51 crore 10 lakhs is paid. So 5 to 5 crore something is the
Balance amount.
balance. Now that's all. The court, that is the respondent to 1 to 3. They filed a court saying that don't pay any money. The second prayer, not to pay in the second prayer. Consequently, issue of permanent injunction restrains the defendant of the society from making any further payment to defendants to tonight. Be it in pursuance of the compromise between part of the court of honorable Senior Citizen General or otherwise on the date of settling the claim of the defendant to tonight. They don't have the they want to see that this litigation goes on forever. Now the society is the person whom we have entered into a compromise. Even if they claim that they are members of the society, they don't have any understanding to, because their rights cannot be larger than the society's rights, because the stream cannot flow over the river.
It appears the dispute between the
see that it's good.
President-
Section 70. No, there is a specific bar under Article 23 would be, that cannot, I am solely relying on Pilokinath case. The Honorable Supreme Court, the Pilokinath case which has been once again confirmed in similar development case. The Supreme Court has very clearly stated that the suit is not made. If this is allowed, this is allowed. The very object of Article 23 does get defeated.
It appears the dispute between the earlier office bearers and the present office bearers. Howda? The office bearers.
ಇವಾಗ ಅಲ್ಲಿ more than 10,000 members ಇದಾವೆ. ಯಾರಿಗೂ ತೊಂದರೆ ಇಲ್ಲ. ಇವಾಗ ಇವರು ಮೂರೇ ಮೂರು ಕೇಸ್ ಹಾಕಿದ್ರು. ಅವ್ರ ಸೈಟ್ ಅಲಾಟ್ ಇಶ್ಯೂ ಅಲ್ಲ. They are not in site allotment. Now the site allotment is 14 hectares. They are put into trouble. They are taken into the cloud. We want to see that at least they ಅವರೆಲ್ಲ ಲೈನ್ ಮ್ಯಾನ್ಗಳು ಅವ್ರನ್ನೆಲ್ಲ ತಗೊಂಡಿರುತ್ತೆ. Now internal their politics.
ನೀವ್ ಯಾರು ಇದ್ರಲ್ಲಿ?
ನಾವು ಲ್ಯಾಂಡ್ 14 acres.
ನೀವು ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್.
For that compensation they are paid peanuts from. Because in the Kadakere, Kadakere and Nagere. We put an end saying that let the poor people of God say let them build a house and keep there. No, because of their internal politics. But second prayer, ನಮಗ್ ಕೊಡ್ಬೇಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಯಾರ ಸ್ಟ್ರೇಂಜರ್ ಬಂದ್ಬಿಟ್ಟು ನಮ್ಗೆ ಇವಾಗ ದುಡ್ಡು ಇಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡು ನಾನು ಕೊಡ್ಸೋದು ಬಡ್ಡಿಯಿಂದ ದುಡ್ಡು. Thank you.
That's all. Yes, Councillor Suman.
Please, my lord. My lord, that the suit, if my lords were to see my plaint which I have now filed annexure G, page 91.
91.
191. The suit was initially filed by defendants. Kindly come to para 3, my lord. Para 3. I shall just read this for my lord's kind appreciation. The plaintiff submits that defendants 2 to 9 had filed a suit in OS number so and so the court below against defendant number 1 herein, who was earlier defendant number 2 and now the sole defendant. Defendant number 1 herein is R4, the society, and one Sampasamy, who is defendant number 1, who is now R5 before your lordship, for the following relief. For a declaration that general power of attorney executed by their brother Venkatagiri, who is who registered as number so and so, is non-enforceable as it's cancelled. Now, my lord, the facts is this: these people were the absolute owners of the extent of about 4 acres and odd in property. They enter into an agreement of sale with the society and execute a power of attorney in favor of the society, the secretary of the society, that is Champaksamy, the 5th respondent before your lordship, who was earlier defendant number 1 in the suit. Now, my lord, a layout is formed. Well, as many as 528 sites are formed. I'm sorry, 258 sites have been formed. 238 is also registered. Only about 21 sites were remaining. At that point of time, the suit is filed, saying, please cancel the power of attorney. The matter was being effectively defended by the society, saying that it is an agency coupled with interest, it cannot be cancelled. We have already paid the sale consideration payable under the agreement. Then when the matter was being convinced, my lord, the persons who are now the respondents before your lordship, were the directors of the company, of the cooperative society, between the period 2013 to 2018. At that time, my lord, some of the miscreant directors decided to enter into a compromise with the plaintiff. There is no resolution passed, or a resolution, if any, is passed behind our back. We have not agreed for the resolution for compromise. Now, what is the nature of compromise? Society will pay 6.5 crores to these people for them to settle the claim. So the moment, my lord, at that time, Champakadhamaswamy R4, who was the erstwhile secretary, he is deleted from the array of parties.
Deleted in the compromise.
In the suit he is deleted because
earlier he was a party.
He was defendant number 1. Now he is removed from the state. Defendant number 2 society, as represented by this coterie of directors who want to collude with the plaintiffs, they enter into compromise. We, the other remaining directors, come to know of this. We file an application under Order 39 Rule, Order 23 Rule 3A, saying that please set aside this compromise. The contention there was this application was opposed, saying that we are not parties to the compromise. And therefore, we have no locus standi to set aside this under Order 39, Rule 3A. Therefore, my lord, we challenge that order before this honorable court in a writ petition. Now, the order passed by this honorable court in the writ petition, Annexure F, page 85.
85.
85. Kindly permit me to, it's a very short order, so I shall just read, my lord, from page 87. It's only a 2 pages order. Petitioners whose application filed under, my lord, we are the petitioners. Under Order 23, Rule 3 of amended code read with 151 CPC for setting aside the subject compromise decree has been rejected, are agreed by the order dated so and so, a copy whereof is at Annexure A, made by the learned additional senior civil judge Nirbangla. Third respondent, that is the second plaintiff in OS number so and so, later numbered as so and so, having entered caveat through his counsel, resists the writ petition. That is one of the petitioners before your lordship. Having heard the learned counsel for the parties, having perused the petition, this court declines to grant indulgence in the matter, inasmuch as the petitioners were not eo nomini, that is parties to the suit or compromise, and therefore they could not have invoked Order 23 Rule 3A read with 151 CPC, seeking vacating of the subject compromise on the grounds which would vitiate a contract on which it is founded. The contention of the contesting respondent that the first respondent cooperative society is corporate aggregate, which is a personality of its members merged, and therefore petitioner cannot lay a challenge to the compromise decree, appears to be too broad a view, in which is not supported by the decision of the apex court in the state of UP versus Scott 1997 so and so. When fraud or like is alleged in as much as apex court in Changalwaya Rayanadu versus Jagannath has held us under, I wouldn't trouble your lordship, perennially everybody is reading the same thing. Suppression of a material document is fraud.
Yes.
Now kindly see para 4, this is important. The last contention of the respondent that the petitioners have worked how to work out their remedy elsewhere is true. It is their contention. It is open to the petitioners to work out their remedy by filing an appropriate suit for challenging the subject matter of decree on the grounds that it would void a contract on which such decree is frauded or on any other ground. In the above circumstances, the writ petition is disposed of with the observation keeping open all contentions of the parties. So, I was directed to file a suit that too on the contention of the very respondent who is now before your lordship, saying that I must file a suit for a declaration that this compromise is null and void and it is vitiated by fraud. My case, specific case, it is vitiated by fraud. My lords would appreciate that when the matter is reached everywhere and hardly 20 sites are left, why should we pay why should the society decide to pay 6.5 crores? This itself is a case of collusion and fraud intercept between the landlords and the then directors of the society. Now,
whether it was a sale for purchase of earlier only for 10 acres and they have farmed the site out total extent of 14 acres.
14 acres fully formed.
But whether they purchased the property to the extent of 10 acres or 14 acres?
14 acres.
14 acres.
14 acres agreement to 14 acres GPA.
GPA.
How though?
Not for 10
not
acres.
10 acres. That is why he wants that to be cancelled. Now, my lord, therefore we filed a suit inter alia referring to the fraud played by
the contention code. The last contention of the respondent that petitioner has to work out their remedy elsewhere is true. It is open to the petitioners to work out their remedy by filing an appropriate suit for challenging the subject compromise.
Yes, sir. Yes, sir. He is a member of the society. Now he alleged that no regulation was passed. No, nothing was proposed to the general body. That is the contention. That is the contention.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಹತ್ರ ದಾಖಲೆ ಬರೀ 10 ಎಕರೆಗೆ ಮಾತ್ರ ಸೇಲ್ ಡೀಡ್ ಆಗಿದ್ದು ಅಗ್ರಿಮೆಂಟ್ ಆಗಿದ್ದು 10 only 10 acres not for 14 acres ದಾಖಲೆ ಇದೆಯಾ?
That's what I was saying. They have agreed. Kindly take the compromise petition. The page number 40.
Then why you have deleted defend number 1 in the compromise?
Because he was the president of the.
As on the date of compromise, whether he was
there from the service. He was party. He was on the day when we talked to him. Therefore, the council was not holding any capacity in the society. When he filed the suit, he was the secretary.
while filing the suit.
Yes. So when we entered to compromise, now he was the officer of the correspondent society.
Ah.
None was in the service because he declared as a compromise.
He was not at the office bearers at the
But
time
he
of
was
compromise.
the power of attorney holder.
Huh?
He was the power of attorney holder.
Power of attorney holder of?
Executed by the landlords as representing the society.
Power of attorney was in his favor.
In his favor, society
But
represented
that
by,
is because he has represented the society.
please.
Hmm.
He had got no rights.
Hmm. Hmm.
It's a society with whom they enter agreement against the power.
Hmm.
So in a compromise, it is this compromise is a compromise.
Hmm.
You know, can you look at the terms?
Paragraph,
Para 3 and 4,
page.
page 42, page 42. Hence, what is the benefit obtained by the society? Yeah, it's paragraph number
42.
page number 42, paragraph number 3 and 4 of the compromise. Para 3, the plaintiffs in the second class society are litigating from more than past 1 decade and with the intention to put an end to the ongoing litigation. The plaintiffs of the defendant society had several rounds of discussion and deliberation from the past 1 year, ultimately by the intervention of the beneficiaries and prominent members of the state, and with active participation of the council of both the sides and the officers of the defendant society, the parties have amicably resolved and settled all the disputes among the plaintiff and defendant society themselves executing. The defendant society, after allotting selling the site to the suit and property, has written two sites in the suit and property, and the defendant society is in the possession of both sides. The defendant society and its office bearer have arrived at a settlement, and as such, both the parties have agreed that after auctioning, selling the retained sites in the settled property, and after collecting additional amount from the site owner, the defendant society has to pay the agreed amount to the plaintiff, agreed amount to the plaintiff. So thereafter, you want to make it, you may not pay it, pay number 46. This specifically agreed by the defendant society here is that the amount realized from the sale of the retained site to the settled property after auctioning and selling by the defendant society shall be utilized for paying the aforesaid agreed amount to the plaintiff as aforementioned, and thereafter the remaining shall be utilized for the aforesaid purpose. The retained sites are amount realized thereof shall not be under any circumstances. Para 6, Roman 6, it is agreed between the parties here that the plaintiffs shall have the first charge of amount realized in the state. And when we hear the remaining amount should be used for the defendant society for development of the layout in the suit and property. The defendant society shall also.
I agree. Where is the mentioning with regard to the earlier only sale transaction for a 10 acres, but sites was formed in total extent of 14 acres, and hence they are entering into compromise with everything.
Para 2, page 41.
41.
Yes, 41.
Ah.
In the case of the plaintiffs, that they are the absolute owners of the property. On the other hand, the defendant society contended that the defendant by virtue of the sale agreement and registered DPA executed by the plaintiffs have found a residential layout in the property, including the kharab land existing in the property, which kharab land is 4 acres 31 gunttas. It was regularized by the competent authority. But
The conversion order.
And subsequent rectification was made in respect of the conversion order. The court makes the plan and the defendant found the layout is and here after the sake of the property. The affordable layout has found that the defendant society after obtaining conversion order from the deputy commissioner, also after obtaining layout plan sanction and all other statutory permissions and approvals. So thereafter, we will not get the relevant point. Let me take 47.
But I'm sorry to interrupt. But how are all these relevant for application of Order 7 Rule 11?
This is very important. Not will get the view of the present compromise petition compromise undertakes to withdraw all the suit, petition, objection, and complaint filed initiated by the plaintiff against the defendant society, officials, right owners, or against the layout.
ಎಲ್ಲ ಇದೆ ರೀ, ನೀವು ನಾನು ಕೇಳೋ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡ್ತಾ ಇಲ್ಲ.
Okay, utilize that.
You argued that only you agreed to sell the property to the extent of 10 acres. But they have farmed the layout to the extent of 14 acres. That's why you have entered into a compromise for receiving an amount of rupees 6 crores. Anta.
Suppose the both GPA as well as the agreement, which is only for 10 acres.
Right.
That cannot be disputed. That cannot be disputed. I had also filed a suit for declaration 262 against the 4 acres additional land. Very next to para 9 that declaration suit also I withdrew. And I confirmed the title of the society for 14 acres 31 guntas.
Right. Including Karab.
Karab.
Karab 4 acres 31 guntas.
Right.
That effect.
Right.
But I also got specifically for 10 acres.
ಹಾಕಿದ್ರ ದಾಖಲೆ ಇಲ್ಲಲ್ಲ.
ಅದು
10 ಎಕರೆಯಲ್ಲಿ 4 ಎಕರೆ 31 ಗುಂಟಾಸ್ ಖರಾಬ್.
What do you say with regard to the judgment of Supreme Court 2026 Supreme Court cases page 6 to 9? Trilokinath Singh versus Anirudh Singh, wherein Supreme Court says interrelationship between so and so, independent suit filed by stranger to compromise, challenging lawfulness of such compromise decree, non-maintainability of separate suit challenging compromise decree.
Yes, my
Person
lord.
questioning lawfulness of compromise.
Look, that is a total stranger to the proceedings. We are not strangers.
Same court which record a compromise. No, but you are at the time of compromise, you are not the office bearer at that time.
My lord,
Maybe
at
you
the
are a
time-
member of the society.
No, my lord, kindly bear with me for a minute. If my lords were to see the 2017, I am the office bearer.
2017 at the time of filing the suit.
Please, at the time of filing the compromise,
Right.
all the 3 of us are not strangers to the proceedings. In
But
fact,
you are a party in the capacity of you are an office bearer.
director of the society.
Howda?
Director of the
Howdu.
society. 2013,
When you have been seized?
2018,
18 compromise.
22/6/2017.
Compromise?
Is dated 22/6/2017. Our office
17 itself.
17 is compromise.
When you are an office director of the society.
Please, without our knowledge and without our concurrence. 2013 to 18, we are the office bearers.
So you are office bearer 2013 to 18.
18. ಆವಾಗ ನಮ್ಮನ್ನು ಬಿಟ್ಟು ಇವರುಗಳೇ ಉಳಿದವರು ಡೈರೆಕ್ಟರ್ಸ್ ಕೊಟ್ಟೇನಿದೆ ಕೊಲ್ಯೂಟ್ ಅಂಡ್ ಡೂ ಇಟ್. ಸೊ ವಿ ಆರ್ ನಾಟ್ ಅಟರ್ ಸ್ಟ್ರೇಂಜರ್ಸ್ ಆಸ್ ಲೇಡ್ ಡೌನ್ ಬೈ ದ ಆನರಬಲ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
Of the society, all the office bearers, including the landowners, along with the respective.
ನೀವ್ ಹಾಕಿದ ಪ್ರಕಾರನೇ ನಿಮ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟವ್ರು ಯಾರು? ನೀವು ಯಾರಿಗೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ರಿ? You being the landlord executed power of attorney sale agreement in favor of whom?
Society represented by president.
President. Who is the president? At that time when his directorship was seized.
Directorship was seized
in 2018, he was a director from 2013 to 18. How you can delete him and enter into a compromise in 2017?
who was the chief holder, he was not a director. The plaintiffs who were filed the court, they are the directors.
ಯಾರು ಹೇಳ್ತಾ ಇರೋದು? ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದೇನು? ಫಸ್ಟ್ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಆಯ್ತಲ್ಲ ಸೊಸೈಟಿಗೆ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ಸೊಸೈಟಿ. ಯಾರು ಅದು? ಹೌದಲ್ಲ, ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದವ್ರು ಯಾರು? ಈ ಸೂಟ್ ಯಾವ್ದು ಫೈಲ್ ಮಾಡಿರೋದು? ಯಾವಾಗಿಂದ ಅವರು? ಆಯ್ತು, ನೀವ್ ಯಾಕ್ರಿ ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ಡಿಲೀಟ್ ಮಾಡಿದ್ರಿ ಅಂತ ನಾನು ಕೇಳ್ತಾ ಇದೀನಿ. ಯು ಆರ್ ನಾಟ್ ಆನ್ಸರಿಂಗ್ ಟು ಮೈ ಕ್ವಶನ್. ಅವಾಗ ಆಫೀಸ್ ಬೇರೆಯವ್ರು ಇಲ್ಲಿಲ್ವಾ? ಇವರು ಇಲ್ಲ he was there up to 2018 ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. ಏನ್ರಿ ಸುಮನ್ ಯಾವಾಗಿದ್ರಿ ಅವರು?
Now the persons who have filed the suit were the directors from 2013 to 2018.
ಆಯ್ತು.
Not Champak Swami. Champak Swami was not the director as on that day.
ಬಟ್ ಆವಾಗಿದ್ದವ್ರು ಯಾರು?
ಆವಾಗಿದ್ದವ್ರು
ಆದಾಗ
Huh?
ಅಗ್ರಿಮೆಂಟ್ ಆದಾಗ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ ಯಾರ ಪರವಾಗಿ?
In favor of Champak Swami, representing the society.
ಆಯ್ತ್ರಿ, ಸಂಪಕ ಸ್ವಾಮಿ at the time of entering into agreement in 2000 ಯಾವ year of agreement?
My lord, agreement is I should just give the date. 17/3/93.
I first you place that agreement and also the general power of attorney. I put you place before the court because both of are not giving correct picture before the court. You place first document of agreement as well as general power of attorney.
After week after next week I'm not in town.
ಇಲ್ಲ ಇವತ್ತಿಗೆ ಮಧ್ಯಾಹ್ನ 2:30.
ಇಲ್ಲ ಇವತ್ತು ಬೇಡ, ಮಧ್ಯಾಹ್ನ ಇವತ್ತು ಫ್ರೈಡೆ ಟೈಟ್.
ಫ್ರೈಡೆ ಆದ್ರೆ
ಅದು ಸ್ವಲ್ಪ ಆ ಕಡೆ ಈ ಕಡೆ
ರಜಾ ಕೊಟ್ರೆ ಸಾಟರ್ಡೇಗೆ, ಫ್ರೈಡೆಗಲ್ಲ.
ಅಲ್ಲ ಮಧ್ಯಾಹ್ನ ಬೆಂಚಸ್ ಇವೆ.
ಬೆಂಚಸ್ ಮುಗಿಸ್ಕೊಂಬನ್ ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ಹೇಳಿ?
ಅಲ್ಲ
court will wait for you.
ಅಲ್ಲ ನನಗೊಂದು ಕಾಪಿ ಕೊಟ್ರೆ ನನ್ನ ಹತ್ರನೂ ಇಲ್ಲ.
ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಏನಾರು ಇದೆಯಾ ಇದ್ರಲ್ಲಿ? ಬೇಕಾಗಿದೆ ಅಲ್ಲ, ಈಗ ಇದೆಯಾ ಅಂತ ಕೇಳಿದೆ. ಇಲ್ವಾ? ಆಲ್ರೆಡಿ ಕಮೆಂಟ್ಸ್ ಆಗಿದೆ, ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಮೆರಿಟ್ಸ್ ಮೇಲೆ. ಇವತ್ ಮಧ್ಯಾಹ್ನ ಅವ್ರೇನೋ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಹೇಳ್ತಾರೆ, ಯಾವಾಗ ಆಗ್ಬೋದು ಹೇಳಿ.
27th
ನಾಳೆ ಸಾಟರ್ಡೆ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ, ಗಂಟೆಗೆಲ್ಲ ಆಗೋದಿಲ್ಲ, ಜಾಸ್ತಿ ಇದೆ ಮೇಡಮ್.
My lord may have it on 27th or 28th. Next week ನಾವು ಊರಲ್ಲಿ ಇಲ್ಲ.
ಫುಲ್ ವೀಕರ್ ಅಲ್ವಾ?
ಇಲ್ಲ.
ಮಧ್ಯಾಹ್ನ ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೋರ್ಟ್.
ಇಲ್ಲ ಅಂದ್ರೆ 27 28 ಹಾಕ್ಬಿಡಿ, ನಾವು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿ ತಗೊಳ್ಳಿ. Third in part, the counsel for the appellant revision petitioner is directed to place the copy of agreement as well as power of attorney and discuss this matter on 27th.
With a copy to the other side ಅಂತ ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಅದರ್ ಸೈಡ್ ನಿಮ್ಮ ಹತ್ರ ಇರುತ್ತೀರಿ? ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ ಅದು?
ಇಲ್ಲ, ನನ್ನ ಹತ್ರ ಇಲ್ಲ.
ಆಯ್ತು, ಒಂದು ಕಾಪಿ ಕೊಡಿ.
Grateful.
ಏನಾಯ್ತು ಅವ್ರನ್ನ ಕೇಳಿ ಹೇಳ್ತೀನಿ ಅಂತಂದ್ರೆ 8 months. ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವೇ ಹೇಳಿದ್ರಿ ಅದು 8 months. ಎಷ್ಟು ರೇಟ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟು ಈಗ ಕೊಡ್ತಾರೆ? 9,000 ಅಂತ ನೀವ್ ಹೇಳಿದ್ರಿ. 8 months ಹಳೆ ರೇಟಾ? 9,000 ಏನಿದೆ ಅದು? 9,000 ಇರ್ಲಿ, 8 months. ಯಾವ ಯಾವ್ದು ಪಿಟಿಷನ್ ನೋಡಂತ? 21 ಒಂದ್ ವರ್ಷ ಕೊಡ್ಬೋದಲ್ರಿ? ನಾವು ಯಾರು 23 1,000 ಅಲ್ಲಿ ಮುಗ್ದೋಗ್ಬಿಡುತ್ತಲ್ಲ. ಆಯ್ತು, ಒಂದ್ 3 ತಿಂಗಳಲ್ಲಿ ಏನಾಗುತ್ತೆ? ಈಗ ಹೆಂಗಿರೋ 8 ತಿಂಗಳು ಕೊಡಕ್ ರೆಡಿ ಇದೀರಿ, ಇನ್ನೊಂದು 4 ತಿಂಗಳು ರೆಂಟ್ ತಗೊಳ್ಳಿ, 11,000 ಮಾಡಿ, 9 ಇರೋದು 11,000 ಆಗುತ್ತೆ. ಅನ್ನೋದು 4 ಆರ್ಡರ್ನೇ ಪಾಸ್ ಮಾಡ್ತೀನಿ, ನಾವು ಕೇಳಿ ನೋಡಿ. ಬಟ್ ಇವಾಗ ಅಫಿಡವಿಟ್ ಹಾಕ್ಬೇಕು ವಿತೌಟ್ ಸೀಕಿಂಗ್ ಎನಿ ಫರ್ದರ್ ಅಂಡ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ಪೇಮೆಂಟ್ ಆಫ್ ರೆಂಟ್. ಈಗ ರೆಂಟ್ ಪೇಮೆಂಟ್ ಅರ್ಲಿ ಅಪ್ ಟು ಡೇಟ್ ಇದೆಯಾ? ಏನ್ ಡ್ಯೂ ಏನಿಲ್ಲ ನೋಡಿ. This matter is the third heard the revision petitioner counsel and also the counsel appearing for the respondent. This revision petition is filed challenging the judgment and decree passed in SC number 347 of 2021, wherein the trial court decreed the suit and directed the petitioner herein to vacate the premises within 3 months from the date of the order. The factual matrix of the case is that the plaintiff is unable to move out of his office, as such, he has executed GPA in favor of Sri Bhanumurthy to conduct the case. Further, it is his case that the mother of the defendant, Srimati R. Rajeshwari, earlier was a tenant in respect of social premises on a monthly rent of rupees 5,500. After the demise, the defendant has been rent up to 1/12/2020 and thereafter not paid the rent to the plaintiff. There is outstanding arrears of rent due to the plaintiff for a period of 3 months amounting to rupees 16,500. The plaintiff requested to pay the rent but not paid the rent. And also it is contended by the plaintiff that the petition premises required to accommodate the watchman, and watchman is necessary to manage the entire building. The provisions of Karnataka Rent Act is not applicable to the facts of the case and hence sought for an order to direct the defendant to return vacate. On service of summons, the petitioner herein appeared and filed written statement and admitted that the mother had occupied the scheduled premises as per the rent note dated 21/11/2006 and and she has done the business in the business premises. And later shop was occupied by him. Also rent has been accepted. Made the payment of rent also. There was no rent due up to December 2020. It is contended that the plaintiff demanded a rent of rupees 11,000 per month and asked to give some more amount as additional advance, but not specified the quantum of additional advance amount. However, he had agreed at the first instance. However, he has not agreed for first instance. Then he had decided to enhance the rent from rupees 5,500 to 9,000. No requirement is made out by the plaintiff and hence sought for the dismissal of the suit. The trial court, after recording the evidence, comes to the conclusion that the plaintiff has made out the case by issuing notice under Section 106 of the Act and allowed the petition, and hence this appeal revision is filed before this court. While arguing the matter on merits, the counsel appearing for the petitioner submits that if 1 year granted time, going to pay the rate of rupees 11,000 instead of 9,000. And since the petitioner has to find out an alternative premises to do the business, counsel appearing for the respondent would submit that 1 year time cannot be given, and court can consider the reasonable time and direct the petitioner to quit and vacate the premises. And also counsel would submit that order was passed in the month of February 2023, still in his occupation, and he has not vacated. Having heard the petitioner, counsel, and also the counsel appearing for the respondent, and the respondent herein also sought for the premises to accommodate the watchman, and watchman is necessary. And this petition is filed in the year 2021. And also material disclosure that the petitioner mother took the premises in the year 2006. In 2006 at the rent of rupees 5,500. And now admittedly rate of rent is paid 9,000 per month. having taken note of initiation of proceedings in 2021, now and we are in 2023, it is appropriate to grant 1 year time, subject to the petitioner making payment regularly without any default at the rate of rupees 11,000, which has been agreed by the petitioner counsel also. And though counsel for respondent inclined to grant 1 year time, however, made submission that at the same rate of rent, the court can consider the reasonable time of 8 months. And having taken note of the said submission also, the court felt that 1 year time would be appropriate and reasonable time, having considered the factual aspects of the case and also considering premise as well as let out in 2006 and the proceedings was initiated in 2021. And hence 1 year time is granted subject to condition that the petitioner has to file an affidavit within 2 weeks today, with an undertaking that he would not seek any further time, and also to pay rent at the rate of rupees 11,000 from 1623 to till 35/24/24. In terms, hence this petition is disposed of accordingly.
It is
ಹಾಕಿದ್ದೀರಾ ಇವಾಗ ಈಗ ಕೊಟ್ರ ಹೇಳಿ. ಅದೇ ರೆಡ್ಯೂಸ್ ಮಾಡಿದಾರೆ ಆರ್ಡರ್ ನೋಡಿದೆ, ಡಿಮ್ಯಾಂಡ್ ಜಾಸ್ತಿ ಇದ್ದಿದ್ನ ಮಧ್ಯದಲ್ಲಿ 25, ಬಾಕಿದ್ರಲ್ಲೆಲ್ಲ ಕಡಿಮೆ ಮಾಡಿದ್ದಾರೆ. ಹಾ ಹಾ
Currently, 29, dated 29/7/2010. What is the order?
ಹಾ 201. Page 28. ಹಾ
Second, whether the applicant further proves that the amount paid to the outside establishment for rate taking charges does not constitute wages as defined. Therefore, the order dated 12/4/2010.
ಆರ್ಡರ್ ಡಿಫ್ರೆಂಟ್ ಡೇಟ್
Different date. And then.
ಚೇಂಜ್ ಮಾಡಿರೋದೇ ಒಂದು ಡೇಟ್ ಆರ್ಡರ್, ಇಲ್ಲಿ ಮಾಡಿರೋದೇ ಒಂದು. ಹಾ
Here, plant and machinery actually. Here, self-selling charges, they say. TCR is required.
ಸರ್ ಇರ್ಬೇಕು ಇಲ್ವಾ ಮೇಡಮ್? Registry is directed to secure the TCR. ಇವತ್ತು ನೀವು ಹಾಕಿದ್ದೀರಾ ಇದನ್ನ ಹಾಕಿದ್ದೀರಾ ಸಿನಾಪ್ಸಿಸ್. The counsel for respondent also filed. Is also furnished to the appellant counsel. Registry is directed ಅಂತಲ್ಲ, the registry is directed to post the matter for admission along with TCR as soon as the same is received. ಮೂರನ್ನು ಸೇಮ್, ಮೂರನ್ನು ಬೇರೆ ಬೇರೆ ಆರ್ಡರ್ ಮೇಡಮ್, ಬಟ್ ಮೂರಲ್ಲೂ ನೀವು ಹಾಕಿದ್ದೀರಾ ಸಿನಾಪ್ಸಿಸ್, ಅದೇ ಸೇಮ್ ಆರ್ಡರ್ ಆದ್ರೆ ಮೂರಲ್ಲೂ. ಇದ್ರಲ್ಲೇನೋ ಮೆಮೊ ಹಾಕ್ತಂಗಿದೆ ಇದ್ರಾನಲ್ಲ. ಇರ್ಬೇಕು ನೋಡಿ, ಮೆಮೊ ಇದ್ದಿದೆ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಮೆಮೊ ಅಂತ ಇದೆ. ಈಗ ಹಾಕ್ತಾ ಇದ್ದೀರಾ ಕೊಡಿ. ಹಾ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪಲೆಂಟ್ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಮೆಮೊ stating that the matter has been settled by executing a partition deed dated 13/2/23 between the appellant and respondent number 1 and 5. Hence, the appeal become infructuous. In view of the memo filed by appellant, appeal is dismissed as infructuous. Appellant counsel 21 metro. Last time ಅವರೇ ಟೈಮ್ ಕೇಳಿದ್ರು. Last time time ಕೇಳಿದ್ರು. Counsel for the appellant seeks time on the ground that senior counsel is still taking treatment ಅಂತ. The counsel for the respondent opposes for taking an adjournment. Seeks time on the ground that senior counsel is not keeping well from 2 days. ಅವತ್ತು ಒಂದ್ ದಿವಸ ಕೇಳಿದ್ರು ಅಂದ್ರೆ ಒಂದು ವಾರ ಕೊಡ್ತೀವಿ. The appellant counsel is absent. Counsel for respondent is present.
Sorry.
MFA.
I'm sorry, my lord.
448 in the
MFA.
serial number
448.
31.
Sorry, my lords. I'm sorry. I was just 448. I'm appearing for the appellant in this matter, my lords.
448 you are
Yes,
appearing.
yes.
ಹೇಳಿ in the matter.
Lords, we are having common vendors. The sale deed under which the present plaintiff is purchased, site numbers 10 and 11. Plaintiff is the appellant. He is on
Plaintiff is the appellant.
Plaintiff is the appellant. He's purchased it on 24/3/2016.
24/3/2016.
Yes. Now this is pertaining to site numbers 10 and 11. Now what the defendant claims is that my predecessors in interest, Lord Srinivas is admittedly the owner of the property. Srinivas's wife and widow and children have executed the sale deed in my favor. The contention of the defendant is that there was a GPA executed by this Srinivas on 4/2/1988, pursuant to which there is a sale deed executed in favor of one Uma Devi, from whom this Javanaya has purchased the property. But that
Sale deed, what is the sale deed?
No,
What is the sale deed?
Sale deeds is of the year that the defendant has purchased it on 24/1/2011.
24/1/2011.
Notes, but the question is this. Notes, if you lodges were to see
GPA holder executed sale deed in favor
of one Uma Devi.
From Uma Devi, defendant has
Yes, has purchased the property. But
what is the date of sale deed of Uma Devi?
let's see 1992, page 77.
1992.
Yes. But the question is this, Minots. The sale deed of 1992 refers to property numbers 138 and 136 as a corner property. 138 and 136.
136.
As a corner property, the property with which we are concerned is site numbers 10 and 11. They are referring to property numbers 138 and 136. If you lodges were to take the boundaries in page number 77 at page 80.
77.
Please. If your lodges were to see, page 80, ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಕೆಂಗೇರಿ ಹೋಬಳಿ ಕೆಂಗೇರಿ ಮುನ್ಸಿಪಲ್ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಟ್ಟಿರುವ ಅಲ್ಗೇರಳ್ಳಿ ಗ್ರಾಮದ ಖಾತಾ ನಂಬರ್ 138 136ನೇ ನಂಬರ್ ಮನೆಯ ಸುತ್ತಗಳಿಗೆ ಚೆಕ್ ಬಂದಿ ಐಟಮ್ ನಂಬರ್ 1 138ನೇ ನಂಬರ್ಗೆ ಚೆಕ್ ಬಂದಿ ಖಾತಾ ನಂಬರ್ 136 ಪಶ್ಚಿಮಕ್ಕೆ ರಸ್ತೆ, ಉತ್ತರಕ್ಕೆ 30 ಅಡಿ ರಸ್ತೆ, ದಕ್ಷಿಣಕ್ಕೆ ಖಾಸಗಿ ಸ್ವತ್ತು. Then kindly have a look at the next page, Minots. ಖಾತಾ ನಂಬರ್ 136ಕ್ಕೆ ಚೆಕ್ ಬಂದಿ ಪೂರ್ವಕ್ಕೆ 137, ಪಶ್ಚಿಮಕ್ಕೆ ಖಾತಾ ನಂಬರ್ 138, ಉತ್ತರಕ್ಕೆ 32 ರಸ್ತೆ, ದಕ್ಷಿಣಕ್ಕೆ ಖಾಸಗಿ ಸ್ವತ್ತು. ಇಟ್ಸ್ ಎ ಕಾರ್ನರ್ ಪ್ರಾಪರ್ಟಿ. 138 is adjacent to 136. After 136 comes 137. So it is like 138, 136, 137. That is how they are describing the property. The same description is carried forward even in the sale deed of the defendant. Now, kindly have a look at the layout plan produced, my lords, in the documents of the defendants at page number 65.
55.
Yes. Notes, your lordships will find Khata site numbers 10 and 11. It's the second row from the top. This is the subject matter.
Page number?
Notes, I'm sorry, notes. Page number 65.
65, no.
Notes, in page 65 in the list of documents filed by the respondents.
Respondents only I'm seeing.
Notes, Mr. Ramesh has filed this, minutes. If there is any mistake in the page number, minutes, I am extremely up.
65 is blank. List of documents antide. Who has filed? I don't know. No, respond number 3. Respond number 3.
Adralli, the layout plan is document number 8, page 55, minutes. I'm sorry, page 55.
55, not the 65.
Sorry. The lordships will find site numbers 10 and 11 is what we are concerned with. That is what they are now claiming as the property, as their property under the sale deed. It is not a corner property, number 1. Because site number 10 should be either 138 in the manner in which they have described, but at any rate, it is not a corner property. And the second aspect, minutes, of the matter is that if your lordships were to again see the sale deed, which is executed in favor of this Uma Devi, which is at page number 77 of my documents, of the appeal papers. This document nowhere refers, if your lordships were to see, minutes, though they have produced what is called as the power of attorney agreement, etc. Then page 77. ಸನ್ 1992 ಬೆಂಗಳೂರು ಮಾಧವನಗರ 2ನೇ ಕ್ರಾಸ್ ಡೋರ್ ನಂಬರ್ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿರುವ ಚಂದ್ರಶೇಖರ್ ಅವರ ಧರ್ಮಪತ್ನಿ ಉಮಾರ್ ಅವರಿಗೆ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಗಂಧದ ಕಾವಲ್ ಸುಂಕದಕಟ್ಟೆ ವಾಸವಾಗಿರುವ ಕುರುಪಯ್ಯನವರ ಮಗ ಸುಮಾರು 40 ವರ್ಷದ ವಸಂತರಾಜ್ ಆದ ನಾನು ಮತ್ತು ರಾಜಾಜಿನಗರ ವಾಸವಾಗಿರುವ ಗಂಗಾಧರಪ್ಪ ನಾನು ವಯಸ್ಸುಳ್ಳ ನಾಗರಾಜ್ ಈ ರೀತಿ ನಾವಿಬ್ರು ಏಕೀಭವಿಸಿ ಬರೆದುಕೊಟ್ಟ ಸ್ಥಿರ ಸ್ವತ್ತಿನ ಕ್ರಯಪತ್ರ. ಇದರಡಿ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ವಿವರಿಸತಕ್ಕ ಸ್ವತ್ತು ಈ ಹಿಂದೆ ತಾರೀಕು 8/1/75 ಮಾಡಿಕೊಂಡ ಪಂಚಾಯಿತಿ ಪಾರಿಕತ್ತು ಮುಖಾಂತರ ಲೇಟ್ ಬಗಲೂರು ಮುನ್ಸ್ವಾಮಪ್ಪ ಶ್ರೀನಿವಾಸ್ ಅವರ ಭಾಗಕ್ಕೆ ಬಂದಿದ್ದು, ಸದರಿ ಕೆಂಗೇರಿ ಹೋಬಳಿ ಸೋಮಸೋ ಶ್ರೀನಿವಾಸ್ ಅವರಿಂದ ಅಧಿಕಾರ ಪತ್ರದ ಮೂಲಕ ನಮ್ಮ ವಶಕ್ಕೆ ಬಂದು ಸದರಿ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತು ಅಂದ್ರೆ ಇದೇ ತಾಲೂಕು ಕೆಂಗೇರಿ ಹೋಬಳಿ ಮುನ್ಸಿಪಲ್ ಒಳಪಟ್ಟಿರುವ ವಲ್ಗೇರಹಳ್ಳಿ ಗ್ರಾಮದ ಅಸೆಸ್ಮೆಂಟ್ ಖಾತಾ ನಂಬರ್ 138, 136ನೇ ಸ್ವತ್ತಿಗೆ ನಾವುಗಳೇ ಸಂಪೂರ್ಣ ಹಕ್ಕುದಾರರಾಗಿ ಮಾಲೀಕರು ಸ್ವಾಧೀನದಾರರು ಆಗಿ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು ನಮ್ಮ ಹೆಸರಿಗೆ ವರ್ಗಾಯಿಸಿಕೊಂಡು ಕಂದಾಯ ನಾವೇ ಮಾಡತಕ್ಕದ್ದು ಎಕ್ಸೆಟ್ರಾ. Now what I wanted to submit with reference to this the recitals of this document is the description of what they are now telling, that they have become the owners of the property, will not be a legally correct proposition, because they have never represented the person whom they are seeking to represent as the power of attorney holder. They can't claim ownership over the property. At any rate, the description of the property does not tally with the description which they want to rely upon for the present. My respectful submission is that your lordships have granted an order of status quo in this matter, my lords, in this appeal. Because I will be in a position to demonstrate if there's a wrong description of the property in the title deeds claimed by them, and if they have not sought for the rectification, I being a third party bona fide purchaser, if there is no rectification, then my title will be safeguarded. So my submission is that till such time, the status of the property requires to be maintained till the suit is disposed. There are grounds for the purpose of maintaining the state of affairs of the property as it stands even as on today. I will undertake, that I will not do anything with reference to the property, though I claim that I am in possession of the property. I am the plaintiff.
Who formed this layout?
Srinivas had formed the layout.
Once he has executed the power of attorney and also the other document. How can he again form a layout in this very same?
He has, according to the defendant, Srinivas has formed the layout consisting of site numbers 10 and 11.
10 and 11, Srinivas.
Yes. Now the sale deed under which Uma claims through the power of through this Vasant and another who have executed the sale deed is Khata numbers 138 and 136. But that is a corner property, which does not tally with the layout plan which the defendant themselves are relying upon.
Whether that property also comes within the layout which you are relying upon?
It is their case because there is only one piece of property. Physically, there is one piece of property that is site numbers 10 and 11. They say what they have purchased is actually site numbers 10 and 11 only. That is the case of the defendant. They say that we are the earlier purchasers of site numbers 10 and 11.
That is the 138 and 139, what they are referring, that is municipal assessment number.
But what I wanted to refer to is that assuming that this is municipal assessment number, there could not be any dispute regarding the boundaries. I can understand, my lords, but boundaries will reflect their property is bounded on two sides. That is on the
vacant site.
Vacant site.
Compound hakidiri. Compound ಇದೆ. Hage irli bidi. So decide agli.
Within 6 months, if your lords were to direct, my lords, I will not take any adjournments. I will cooperate with the trial. No, it's only an obligation on me, my lords. I am not saying that the court should give a direction. I understand the restrictions. I will say, my lords, that I will endeavor to complete the suit before the trial court within a period of 6 months without taking adjournments.
Survey number? Both are claiming from him only. Vasantraj and J.G. Nagaraj. ಆಯ್ತು. And also the Parapatani. ಆಯ್ತು. ರೋಡ್ ಫಾರ್ಮೇಶನ್ ಆಗ್ದಲ್ಲೇ ಸೈಟ್ ನಂಬರ್ 10 and 11 ಐತ್ ಕೊಡಕ್ಕೆ ಯಾರು ಮಾಡಿಫೈ ಮಾಡಿದ್ಕೆ ಏನಾದ್ರು ದಾಖಲೆ ಇದೆಯಾ? $1992. While formation of road earlier they have sold 30-40 into two sites in favor of Vasant Raj and also J.G. Nagaraj. According to you, again road was farmed. While farming the road, 50% of sites, one matra, or remaining 30 plus 15, 45 uliyutte anta. Both of them sold 45 into 40. Madevi.
Since the property is continuing mining, but selling the property, but giving the property on the paper, when selling the property, instead of mentioning the site number, they have mentioned only
Kata number, right? Page number? One second. 25. 25. 15 into 40 ಇದೆ. ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. Same also 10 by 11.
By selling this property, my way. And by selling property, my way. Khata number allocation. After you have this property, have a registered certificate, 24/1/2011.
2011.
From 1992 onwards, this central government, you are paid still property.
ಆಯ್ತು.
Property tax. Now, taking into account non-mention of this site number.
Site number. Srinivas died in 2008. 212.
Now, not mentioning the site number in our side. The right of the Srinivas and implement is really in favor of
Plaintiff that is mentioning site number 10 and 11.
10 and 11. On 24/2016. The trial court will also have to protect the other part. The reason is the trial court. And the 18. Okay, from that. The vendor stated that all the revenue documents are pending in their name. But the credits are not produced documents so that the zoo property was standing in the name of the vendor as on the date of execution of the sale. Therefore, the plaintiff has been 2016 onwards. Now we are motion to continue with the legal way. They have stated. Of them, and the vendors are regularly paying the tax. They have not produced any document. They did not market.
Except the sale did, no other documents. Not maintainable. Now suit is for only for bare injunction. First GPA ಮತ್ತೆ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿರೋದು ಈ ಶ್ರೀನಿವಾಸನ in favor of Vasantraj and the Nagaraj also. That is in site number 10 and 11 only. Right.
In their favor, through the wide system of we are from 1988.
ಕಾಂಪೌಂಡ್ ಹಾಕಿದಿರಾ? ಯಾಕೇನ್ ಹಾಕಿದ್ರಿ ದಾಖಲೆ? ಏನಾರು ಫೋಟೋಸ್ ಹಾಕಿದ್ದೀರಾ?
It's the plaintiff's case that they have put up the compound. Ultimately, there is a compound put up. I am not disputing.
That's all. ಅಷ್ಟೇ ಅಲ್ಲ?
Just one
Any reply,
sentence.
Ravi?
Milords, I'll just say that there are pre-existing documents of Khata, and after the sale deed, there is Khata in the name of the present plaintiff appellant, which your lordships will find at page numbers 26 and 27. So,
Ravi, what are the documents prior to purchasing of the property by your client?
Lords, if your lordships were to see that page number page 22 is the sale deed, and after that there is a Khata.
There is a sale deed. Before that, I am asking you.
Before that, of course,
The vendor should have the title to sell the property in favor of your client.
yes.
You have to make out a prima facie case by showing the document for granting of an injunction order. Where is that document?
What's the title being in this Srinivas and his LR's Milords cannot be a fact of dispute, because we are not disputing the vendor's title.
Srinivas himself has sold the property in earlier 1998 by executing power of attorney.
That's the reason why I
And
said.
power of attorney holder also executed the sale deed in the year 1992 itself.
Milords, I fully concede.
By
Milords.
mentioning the very same site number 10 and 11 only.
Milords, the
What is
description of the
the, what is the
property.
prima facie
Milords,
case to grant an order of injunction?
Milords, I'll just indicate, Milords. The description of the property as reflected pertaining to the first sale deed which comes into existence in the year 1992 is pertaining to property numbers 138 and 132.
That is Khata number what they have.
That's the reason why I'm mentioning, Milords. If there is whether it's the same property which is assigned with Khata numbers 138 and 136 would be a matter of trial, because if at the time of purchasing the property, if the encumbrance pertaining to survey numbers 10 and site number 10 and
Even,
site number
even
11,
while mentioning the Khata 138 and 136 also, in the very document of the concerned department, mentioned the site number 10 and 11 also.
this, if your lordships were to see the document, Milords, that whatever is written in the brackets is a little overwriting, Milords, if your lordships were to see that. The document itself, which
That's all. Now only court has to see only granting an injunction order prima facie case. That's all.
Lordships.
Or the appellant counsel and also the counsel appearing for the respondent. This appeal is filed challenging the order passed by the trial court in rejecting the application filed under order 39 rule 1 and 2 and allowing the application filed under order 39 rule 4 read with section 151 of CPC. ಹೇಳ್ರಿ ನೀವ್ಯಾರಿಗೆ?
Milords, I'm sorry to interrupt, Milords, because I don't know whether they have filed those documents. Milords, I have the
ನೀವ್ಯಾರಿಗೆ?
Milords, I am representing him. The Khata pertaining to this property as on the date of purchase, that is serial number 336, property numbers 10/11/26/2 was standing in the name of Lakshmi Devi, BBMP Khata. And admittedly, this is a property which is come within the limits of BBMP as on the date when the sale deed is executed in my favor. So prior documents of Khata also stood in the name of this Lakshmi Devi, who is my vendor. Because your lordship specifically asked, Milords, what was document standing in their names, and this is from the years 2008. Milords, this
Lakshmi Devi.
Yes, Lakshmi Devi, this entry has been standing. Therefore, Milords, it is not as though that for the first time the entry comes in the name of, because the contention raised by the defendant is that there was no prior Khata, but the Khata came to be entered in the name of the plaintiff for the first time, after the sale deed is not factually correct. That's the
What is the basis for this document?
No, it's, the basis is that I have also produced the encumbrance, site numbers 10 and 11. There is no encumbrance, pertaining to this property. If your losses were to recollect, section 34 of the section 32 of the specific leaf act, if there is any instrument which does not describe the property in a manner that it can be identified, then any person who purchases the property, if there is an earlier misdescription which is not ratified, stands protected. The reason why I am submitting this is that if it is not reflected in the encumbrance and if the khata is standing in the name of Lakshmi Devi, if I have purchased the property, then it's a matter of trial whether the property which is actually purchased by the defendants would be the property which is presently.
Now I am not deciding a title.
I understand.
Under Order 39 Rule
Yes,
112.
the only thing which I wanted to only thing which I wanted to mention is that that in the since it is a vacant site, though there is a compound, if your lordships were to give a direction for expedited disposal of the suit, where I will cooperate, I am not saying that the direction should be against the court, but the direction against the plaintiff as such. Because if the nature of property changes on the premise that any adverse orders were to be passed, then the suit becomes infructuous. Nothing remains to be adjudicated in the suit because it's a suit for injunction.
That's right.
Please, that's all the submission. Great.
Equity in case of any construction.
I would also say the same thing, Milords. If I am permitted to put up construction, I would put it this way, Milords. If I were to permitted to put up the construction, I will not even claim the cost of construction if I lose the suit number.
I am not permitting. I am only considering the 39. So, 39 Rule 4 vacating the interim order granted earlier. The factual matrix of case of plaintiff before the trial court when seeking an interim order of injunction, he said suit that he had purchased the property which is mentioned in the schedule, where sale deed dated 24/3/2016, which measures east to west 43 feet, north to south 40 feet, which is described in the suit schedule property. Also contend that all the documents stands in the name of the plaintiff. That on 21/9/20, when the plaintiff was getting clean the suit schedule property, then the defendant number 2 and his henchman, that is defendant number 1 and 3, who are absolutely strangers to the suit property, tried to trespass and interfere with the plaintiff's possession and hence resisted the illegal act of the defendants and sought the relief of injunction. The defendant number 3, consequent upon notice issued to the defendant, comes up with return statement stating that survey number 26/2 originally belongs to M. Srinivas. The vendors of the plaintiff are the legal heirs of said M. Srinivas. The said land, the said land owner farmed residential sites in 2 acres, 7 guntas. He sold site number 10, measuring 30 into 40 feet in favor of K. Raj on an agreement of sale dated 4/2/1988 and also executed a GPA. Accordingly, he sold site number 11, measuring 30 into 40 feet in favor of J.G. Nagaraj under an agreement of sale dated 4/2/1998 and GPA after receiving the sale consideration. The purchasers got changed the khata in their names and the khata number 138 is assigned to site number 10 and 136 assigned to site number 11. In a portion of site number 10, a road is formed by using 15 into 40 feet and the remaining area is only 15 into 40 feet. The said measurement is also entered in the khata of K. Vasantaraj. both the said purchasers have sold the site number 10 and 11 in favor of Uma, Srimati S. Uma, under a registered sale deed dated 8/5/1992, based on the GPA executed by late Srinivasa. And she also got changed the kata in her name and paid the tax. And thereafter, the defendant has purchased the said property under registered sale deed dated 24/1/2021 from Srimati Uma, and they have become absolute owner, and they are in peaceful possession and enjoyment of the suitable property. It is contended that plaintiffs have created documents when the site number 11 and 10 and 11 are already sold by the husband of vendors of the plaintiff. Question of again selling the property doesn't arise and the same doesn't convey any right in favor of the plaintiff. Trial court, having considered the pleadings of the plaintiff as well as the defendant, and formulated the point whether the plaintiffs have made out a prima facie case and balance of convenience and hardship, and answered the same as negative, it coming to the conclusion answering point number 4 as affirmative that it will cause hardship to the defendant and balance of convenience in favor of the defendant. Hence, the present appeal is filed before this court. The counsel appearing to the appellant would vehemently contend that future property was sold by the legal heirs of Srinivasa, and the same is not in dispute. And also, counsel brought to notice of this court layout copy, wherein site number 10 and 11 comes within the layout, and the same are not corner site. And now the schedule mentioned in the document of the defendant's vendor shows the property what they have purchased is corner property, and only mentioned assessment number 138 and 136. The council also would contend that before the purchase of the property, the year 2016 also, records are standing in the name of wife of Srinivas, and could I produce along with memo some of the documents with regard to the partition deed of 1975 and also the death certificate of Srinivas, and copy of the family tree of appellant, and copy of the EC in respect of site number 10 and 11 for the year period 2015 to 17, and copy of the kata certificate of appellant vendor, and copy of the taxpayer receipt. The council would vehemently contend that even the EC also discloses with regard to the sale and made out the prima facie case. The council also would submit that the suit scheduled property is a vacant site. And this court already granted an order of status quo, and status quo may be continued, and direction may be given to the plaintiff to assist the court in disposal of the case within a time bound period. For contra, counsel appearing to the respondent would vehemently contend that no dispute with regard to the fact that survey number 26 belongs to the Srinivasa, and he had farmed sites in the said survey number during his lifetime, and also sold the sites not only to the original purchaser Vasantraj and JG Nagraj, and also sold the sites to the other prospective purchasers by executing the sale agreement as well as general power of attorney. The council also vehemently contend that the very general power of attorney holders on acquisition of portion of the property for utilizing of the portion of the property belongs to the Vasantraj to the extent of 15 into 40 feet. Both the power of attorney holders have executed the sale deed only to the extent of remaining extent of 45 into 40 feet. And the state Uma Devi also executed the sale deed in favor of the defendant in the year 2011 itself. The council also brought to notice of this court, even in the municipal records also, the extent of in the municipal records also, survey number, site number 10 and 11 is also mentioned, and so assessment number is also mentioned as 136 and 138. And the description variation is with regard to the formation of road in respect of the sites which belongs to the Vasantraj. And when all the documents clearly discloses that the defendant is having the prima facie case, the trial court having considered all this material and record, giving the reasons, comes to a conclusion that plaintiff has not made out any prima facie case and hence not granted any order of injunction and vacated the earlier order granted by the trial court by allowing an application and not committed any error. Having heard the respective counsel and also perusal of material based on the sale deed dated 24/3/2016 and suit is also filed for the relief of permanent injunction. And now title is also in dispute between the parties. And suit is also for only bare injunction. And when there is a cloud on the title in respect of the suit said property, the better relief has to be sought. And apart from that, it is not in dispute that sites are farmed in survey number 26 of Kolagairhalli village and properties also belongs to the said Srinivasa. The plaintiff claiming the right based on the sale deed executed by the legal heirs of said Srinivasa and the agreement of sale as well as GPA is also in respect of site number 10 and 11, which was executed in the year 1988. And also in the present sale deed, plaintiff who is claiming the right in respect of site number 10 and 11 is also formed out of very same survey number of 26, which belongs to the original owner Srinivasa. And subsequently, the GPA holders also executed the sale deed in favor of the defendants. In favor of the vendors of Srimati Uma. And they have executed sale deed in favor of Uma and Uma in turn executed sale deed in favor of the plaintiff in the year, defendant in the year 2011. When such being the case, where the property is already sold by the said Srinivas, and now the question is whether the vendors of the plaintiffs are having title to convey the title in favor of the plaintiff. And this aspect has to be considered during the course of trial and not at this stage. And only the plaintiff has to make out a case for granting an order of injunction and not made out any prima facie case to grant an order of injunction, invoking under order 39 to 1 and 2. On the other hand, defendants have claimed the right in respect of the very suit property, relying upon the documents of the year 1988 onwards, which have been executed at the first instance by the Srinivasa. Such being the case, I do not find any error committed by the trial court in allowing the application filed under order 39 to 4, and hence I do not find any merit in the miscellaneous first appeal to reverse the finding of the trial court and grant any order. No merit in the miscellaneous appeal. In view of the discussions made above, I pass the following order. The trial court is directed to dispose of the year the suit. 21. 20. Bangalore. The trial court is directed. City court. The trial court is directed to dispose of the matter within a period of 1 year. And both the parties are and counsels are directed to assist the court in disposal of the case within the time stipulated. ನೋಡಿ ಟ್ರೈಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿರೋದ್ರಿಂದ ಮೋಸ್ಟ್ಲಿ ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ಬರ್ಬೇಕು ನೋಡಿ ಅದಕ್ಕೋಸ್ಕರ 1 ವರ್ಷ ಕೊಟ್ಟಿದ್ದೀವಿ ಇಲ್ಲಾಂದ್ರೆ 6 ತಿಂಗಳು ಕೊಡ್ತಾ ಇದ್ದೀವಿ.
I understand, my lord.
You have to seek for relief of
Declaration of title. Please, read from the notes.
32.
Copy was served on the study last time.
ಲಾಸ್ಟ್ ಟೈಮ್ ಅನ್ನು ಮಾಡಿದ್ವಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದೀವಿ ಅಂದ್ರಲ್ಲ.
Even before that it was complained, he has signed it daily. I don't know what has happened in this matter.
ಹೇಳಿ at least allow him to make submission. ಹೇಳಿ ಅದೇನು ಹೇಳ್ತಾರೆ ನೋಡಿ. ಹೇಳ್ರಿ ಏನು you are representing who? 8, 12 and 13. Copy
I checked, my colleague checked the.
serve ಮಾಡಿದ್ರಿ ಇಲ್ಲ?
There are only 3 Wakalas there on the file, all of them were strong copies.
Huh. ಏನ್ ಆರ್ಡರ್ ಕೊಡ್ರಿ ಅದನ್ನು? You are appearing for R7 R6 first one ಅಲ್ಲಿ R7 ಇದ್ದೀರಿ ನೀವು. He is appearing for R1A. ಯಾರೋ ಒಬ್ರು BL ತೇಜಸ್ ಫಾರ್ ಏನು KVTR number 13.
R1A is the
Brother of the plaintiff.
contesting,
ಏನ್ರಿ ಆರ್ಡರ್ 29(3) ಅಲ್ಲಿ? Appellants are directed to furnish the particulars as regards total number of apartments, flats constructed on item number 5 and 6 of the suitable properties, the total number of apartments sold as on today, the latest details of the transaction entered into by the appellants in relation to the apartment, the details of that is with regard to the details is concerned. Copy, you permitted to registry to print the name of Kin Munche for the reason stated in the affidavit accompanying the allowed and is permitted to brought on record as legal representative, respond number 1 in MFS and respond number 13 in MFS, so and so, so and so. It is particular as the council appearing respond only and so and so, respond number 8 will under MFS, so and so, so at the request of the learned council for the appellants, relist this matter ಅಂತ ಆಯ್ತು. ಆಯ್ತು. ಆಯ್ತು ಅದ ಆಮೇಲೆ ನೋಡೋಣ. ನಿಮ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಎಲ್ಲಿದೆ ತೋರ್ಸಿ ಫಸ್ಟ್. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ನೀವು ಫಸ್ಟ್ ಕಾಪೀಸ್ ಕೊಡಿ ಅವರಿಗೆ. ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಕಾಪೀಸ್ ಕೊಡದಲ್ಲ ಹೇಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ ನೀವು? ವೈ ಆರ್ ನಾಟ್ ಸರ್ ವೆನ್ ದಿ ಅಡ್ವೊಕೇಟ್ permitted to come on record.
He said he didn't get copies last time. I gave it to him. He was not there last time. He didn't ask for it. I didn't know he's appearing.
ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರ ಏನಾರು ಇದೆಯಾ?
No interim order.
No interim order.
The appeal itself will be disposed of.
I will dispose it up on main only. You serve the copy. You give an opportunity for them also to represent the case by serving the copy. Then I will decide the case. ಕೊಡಿ ಈಗ ಕಾಪೀಸ್ ಕೊಟ್ಬಿಡಿ. ಮೂರು ವಕಾಲತ್ತು 3 ಜನಕ್ಕೂ ಕೊಟ್ಟಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಕೊಡಿ. ಏನು ಕೊಡ್ರಿ ಮೇಡಮ್? ಯಾರ್ಯಾರ್ದೆಲ್ಲ?
13 and 7.
Advocate for responding. Apartment constructed on items of 5 and 6 scheduled properties in survey number 41. This is most probably you have given details with regard to the as per the court direction. Howda?
Yes, sir.
But memo idನ್ನು ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು. Appeal memo. What are the documents you have filed along with this? Yeah, serve the copy. Appeal memo ಕೊಡಿ ಅವರಿಗೆ. ನೀವೇನ್ ಕೊಟ್ಟಿರೋದು 7/6/23 ನಲ್ಲಿ ವಾಟ್ ಎವರ್ ಯು ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ದಟ್ ಈಸ್.
Yes, taken a copy of what is already been served on him. If the appeal memo is not served, I will serve on the date of the appeal memo. Whatever he wants, I give it to him. There is no difficulty.
Here there is a compliance memo as per order dated 29/3 ಇಂತ 6/6/23 ನಲ್ಲಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಿರಿ.
Again, I have given again another copy of the same.
ನಾವು ಏನ್ರಿ ನಿಮಗೆ ಅಪೀಲ್ ಮೆಮೋ ಇಲ್ಲಿಲ್ವಾ? ಈಗ ಇಸ್ಕೊಂಡಿದ್ದೀರಿ. ಹಾ ಏನ್ ಸರ್ ಮಾಡಿ? ಈಗ ಯಾವ್ದು ಕಾಪಿ? ಹಾ ನಿಮಗೆ ಈ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಫಿಡವಿಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ವಾ? ಕೊಟ್ರಾ? ಹಾ ಆಯ್ತು. ಈಗ ನಾವು ಈಗ ಎವ್ರಿಥಿಂಗ್ ಈಸ್ ವಿತ್ ಯು. ಸರಿ ಹೋಗ್ಲಿ, ಯಾವಾಗ ಬೇಕು ಹೇಳ್ರಿ, ಅಟ್ಲೀಸ್ಟ್ ಏನ್ ಟೈಮ್ ಬೇಕಾ? ಈಗ ಏನ್ ಬೇಕು ಹೇಳಿ. ಈಗ ನೀವು ಆರ್ ಯು ರೆಡಿ ಬೋತ್? ಆಯ್ತು, now they have served the copy. Agreement for sale for what? Hmm.
If there are violation of the injunction order, that is for him to take action against me in a separate forum. Okay? I am asking, according to me, I have complied with the order by producing the documents that I have. If I heard,
Yes, find memo along with compliance. Hmm. 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 I three, yes, in terms of the memo and also in detailed materials, what they have placed before the court, how much agreement they have entered and how much documents are executed. Court wanted to know how many agreements are entered into and also how many deeds, conveyance deeds are executed. Why you want those the agreement? Is there any dispute? Hmm.
I didn't appeal. I didn't apply. I didn't apply.
At the time of passing an order. Hmm. 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 Hmm.
That also has some value. Okay, I want to be also have to be based on record to understand from what dates were they executed.
Now they have also sought for modification of the order also. One more IA they have filed in IA. Modification of the earlier order. They will filed a statement of objections to this IA. Hakilla. Copy was served on 7/6 itself. Along with some documents also they have produced. The counsel for the appellant has furnished the document, furnished the appeal memo to counsel for R13 and also R8, 8, 12 and 13. 8, 12 and 13. Counsel for the respondents seeks time to file objections to IA number 2/23 for modification of the earlier order and hence list this matter. I will give 1 week time. No explanation, then state of hearing. List this matter, put it, madam, 23. First Wednesday criminal matters ಎಲ್ಲ ಇರುತ್ತೆ ಅದಕ್ಕೋಸ್ಕರ Thursday ನೋಡಿ 22nd. 22nd ಆಯ್ತು 22nd. ರಾಮಮೂರ್ತಿ HS. Hmm? Hmm. 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 73. Ah. Hmm. 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 Hmm.
Unless they depend on the 3 nuts, without there being any right in respect of the star. Therefore, unless they causing a interference with the and instead of us now developing interest activities and us now the
Hmm. Photographs.
developing interest activities.
Hmm.
Now they are constructing without
ಏನು ಡೋರ್ ಏನೋ ಚೇಂಜ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Huh?
entire construction. They're being right to us, they're trying to interfere with the peaceful process. Now there is,
ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಲ್ಲಿ?
ನಾನು ಮಾಡ್ತಾರೆ.
ಏನ್ನ?
Entire development is, and we interesting us, if I kind of the interest statement by the one, that is number 3.
Hmm.
That there is a simple long reference letter. Both fathers are
Hmm.
my village reports.
ಆಯ್ತು, go to the reasoning of the trial court. Ah. 17. Ah. 17. But looking at the plain government, it indicates that said trust appears to have created by plaintiff to perform puja in Sri Koshana Kali temple. Admittedly, the said temple is the temple belongs to the Mujrai department of the Bardidarantana. Neither the plaintiff nor the plaintiff trust owns the said temple. Rather, the documents relied upon by the plaintiff also indicate that the defendant also got created one more trust. Apart from that, the materials on record clearly indicate that there are several litigation pending adjudication between the plaintiff and defendants, which indicates that both plaintiff and defendants are fighting for rights to perform puja in temple. As rightly argued by the learned counsel for defendant, temple belongs to Mujrai department, that is government, nor belongs to either plaintiff nor belong to the defendants. And just because somebody created a trust by themselves, that will not be in any way create any title either to the plaintiff or to the defendants in respect of so-and-so, which admittedly belongs to Mujrai department. Is the reasoning. Hmm. Hmm.
Same pattern, this is from this table, it's later, 20 are really right. All the social control, that's an right. In the future, you know that social control, under these circumstances, what are the basis of the operation now?
Who farmed the trust? Who farmed the trust? ಏನ್ ಹಾಕಿದ್ರೆ ದಾಖಲೆ ಏನ್ ಹಾಕಿದಿರಿ ಹಿಂದೆ? ದಾಖಲೆ ಏನ್ ಹಾಕಿದಿರಿ ನೀವು ಫಾರ್ಮ್?
Page number 67.
ಈ ಉಲ್ಲೇಖ ರೆಫರೆನ್ಸ್ ಮಾಡಿದ್ರಲ್ಲ ಭಾಗ್ಯ ಅಂದ್ರೆ ನೀವು.
ಹೌದು, ನಾನೇ ಮಾಡಿ.
ಹಾ.
Page number 67 I have made another two things. Page number 25 to 99. Pending for consideration.
Next, sir. Annexure K ಒಂದ್ ಬಿಟ್ರೆ ಬೇರೆ ಏನ್ ಹಾಕಿದ್ರಿ ಅಂತ ಕೇಳಿದೆ ನಾನು. Annexure J is only the plain copy. ಸರಿ ರೀ, ನೀವು ಇಂಜೆಕ್ಷನ್ ಕೇಳುವಾಗ ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ ಕೇಳಿದೆ. ದಿಸ್ ಇಸ್ ಓನ್ಲಿ ಅ ಲೆಟರ್ ಗಿವನ್ ಬೈ ಯು ಟು ಕಂಟಿನ್ಯೂ ದಿ ಪೂಜಾ ಅಂತ. ಅದಕ್ಕೇನ್ ಹೇಳಿರೋ ಹೌದು ಇಲ್ಲ ಇಲ್ಲ ದಿಸ್ ಪ್ರಾಪರ್ಟಿ ಟೆಂಪಲ್ ನಾಟ್ ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ ಮುಜರಾಯಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. ಒಳಪಡದೆ ಇರುವುದೇ ಮನವಿ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ತಮ್ಮ ಹಂತದಲ್ಲಿ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಕೋರಿದೆ ಅಂತ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಬರೆದಿದ್ದಾರೆ. ವಾಟ್ ಇಸ್ ದ ಡಿಸಿಷನ್ ಟೇಕನ್ ಬೈ ದಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್? ಸರಿ ರೀ, ಇಂಜೆಕ್ಷನ್ ಆರ್ಡರ್ ಕೇಳ್ಬೇಕಾದ್ರೆ ಏನ್ ದಾಖಲೆ ಹಾಕಿದಿರಿ ನೀವು? ಏನು ಹಾಕಿಲ್ಲ, ಬರೀ ನೀವು ಯಾವ ಪ್ಲೈಂಟ್ ಗಳು ಹಾಕಿರೋದು ಸೂಟ್ ಹಾಕಿರೋದು ಮಾತ್ರ ಹಾಕೊಂಡಿದ್ದೀರಿ ನೀವು. ಈವನ್ ಟ್ರಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ, ಏನಿಲ್ಲ. ನೀವು ಫಾರ್ಮ್ ಮಾಡಿದ್ರಿ ಟ್ರಸ್ಟ್ ಅನ್ನೋದಕ್ಕೆ ಏನಿಲ್ಲ, ಎಂತದೂ ಇಲ್ಲ. ಇಂಜೆಕ್ಷನ್ ಕೊಡಿ ಅಂತ ಬಂದ್ರೆ ಏನ್ ಮಾಡೋದು ಹೇಳಿ? ಅದೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕ್ತಿರಿ, ರಿಲೇ ಮಾಡಿದಿರಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲಾನು ಹಾಕಿ ನೀವು ಕೋರ್ಟ್ ಮುಂದೆ, ಅಥವಾ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದ್ರು ಕೊಡಿ, ನೋಡೋಣ. ಲುಕ್ ಇಂಟು ಇಟ್. ನೋಡಿ, counsel for the appellant seeks time to place documents.
I'm appearing for defendant number 1 through VC, my lord.
Through counsel for ನೀವು ಯಾರಿಗ್ರಿ?
D1 sir.
3. But she also saying that 1 to 3.
One only, my lord.
Your Sebastian
Only
is
one.
for R3.
Defendant number 1.
You know, pending for acceptance ಇದೆ ಏನು ಮೇಡಮ್ ಅದು? That is already ಮಾಡಿದ್ವಲ್ಲ consideration. Notice not ordered in respect of R2. Komala for R1. Manjunatha G
R1,
for
my lord.
R4.
Yeah, I'm
Who is
present in the
appearing
VC,
for
my lord.
R2 ಗೆ ಯಾರು appear ಆಗೋದು?
Trial court ಅಲ್ಲೂ ಯಾರು appear
Notice
ಆಗಿಲ್ಲ
order
R2 ಗೆ ಸ್ವಾಮಿ.
ಇವರೆಲ್ಲ ವಾಲಂಟರಿ ಬಂದಿರೋದಾ?
ಹಾ ಸ್ವಾಮಿ.
The appellant counsel is directed to serve the copy of this appeal memo on the counsel appearing for R2 before the trial court. Service ಮಾಡ್ಬಿಡಿ ಅವ್ರಿಗೆ.
ನಮಗೂ ಸರ್ವಾಗಿಲ್ಲ ಸ್ವಾಮಿ, R1 ಸರ್ವಾಗಿಲ್ಲ.
The appellant counsel also directed to serve the copy of appeal memo on the counsel for R1. ಮಂಜುನಾಥ್ ಜಿ ಫಾರ್ R4 ಇದಾರ. ನಿಮ್ಗೆಲ್ಲ ಕಾಪಿ ಬಂದಿದೆಯಲ್ಲ, ಮತ್ತೆ ನಾಳೆ ಕೇಳ್ಬಾರ್ದು. ಅದಕ್ಕೆ ನಿಮ್ಗೂ ಕಾಪಿ ಬಂದಿದ್ಯಾ? ಆಯ್ತು. From the copy and list this matter on 3/7. Sampath Anand Shetty. $59. Now for sons, will, if deed. Filed a suit.
On the ground that the conditional decree, which I produced. What she says that and the clause B of the prayer tenants, 7 to 17, they are the tenants of the current lordship.
Deposit the rent to the plaintiff bank.
This is the main priority.
Hmm.
By way of interim injunction,
Hmm.
the trial court at this stage,
Hmm.
without examining any of the is straight away directed, even 7 to 17 tenants to deposit the rent. What will be the final prayer is already granted by your interim mandate injunction. Now, even the plaintiff has not approached the court, he had, which I am able to demonstrate. Now, her condition that on the same day, on 13/6/2019, there was one MOU which ought to have been executed, complied by the sons. Now, she says that memorandum of understanding are produced page 74. Now, the relevant page is 76. Whereas the first party is hereby declared that the second party, that they are their sons, the parents, shall be liable to receive all the benefits and debtors which arise from the building till their remarriage, and the state in normal views shall also be responsible to interact with the tenant of the building, and no other brothers shall interact with the building occupants in the way. They say, and these are the conditions. Now, admittedly, MO is an unregistered document. 36 is the registered, 50 is the registered document. By virtue of that, since according to the plaintiff, there is a violation of the MOU, by virtue of that, she is entitled to revoke. Now, in this court, she has virtually suppressed.
But this MOU, you are the party.
Yeah, I am the party, but the condition also, I have complied with the conditions. Notwithstanding that, the condition being, I have required to deposit the amount to the particular account. In fact, she has produced this document for the court. However, the original of the document at page document number 4, it's a KCM document. Now, in this plot at page 80, you must put the account number.
Yes, blank antana.
In fact, this is nothing but original. Now, I have this, apart from that, it is these conditions I have complied with. I am able to demonstrate. Her only complaint is that after she executed 50, she is not able to maintain herself. The entire amounts are being deposited by the tenants directly to her sons. So she is not able. That is a summary success. That is falsified from her own account statement, which is produced before the trial courts. They have been depositing all the sons. They have been depositing, which I am able to demonstrate. Apart from that,
Tenants are paying rent to the whom? Rent to whom?
they are paying rent. So they say according to her. Apart from that, you are not supposed to see the tenants have replied to her legal notice, which is at page 84, document number 6. Where they say that we have all entered into an agreement with your sons. And they are continuing to own us. So we have to pay the rent. For her maintenance. These sons, kindly see at page 86 at document number 7. Now, this is one of the tenants on 10/4/2019. 18,000 is deposited in the account of plaintiff, Razama Sultana. Then again, Reliance Corporate, one of the tenants, 58,980. And
On what date?
on 18/4/2019.
18. 18.
Yes. This is prior to that. Refer to page 87. In 6. Tenants who understanding that there are evidence to show around account statement, prove that these sons have been depositing the rents, even the tenants also have been depositing. And the tenants together gave a common reply, which I have put in page 80. Is that kindly see at page 84. As per instruction from my client, all the tenants have common reply. from my time with the reserve document.
ಅಲ್ಲ ರೀ ರೆಂಟ್ ಕಟ್ತಾ ಇದೀರಿ ಆಮೇಲೆ ನಿಲ್ಸ್ಬಿಟ್ಟಿದಿರಲ್ಲ 22 ಮೇಲೆ 22 ಅನ್ವರ್ಸ್ 22 ನಲ್ಲಿ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರು ಎಲ್ಲಿ ಯಾವ್ದು ಬರೀ ಒಬ್ಬರ ಇದ್ರು ಕಟ್ಟಿದ್ದಾರೆ 100 ಒಂದೇ ಇಲ್ಲ ಅದಕ್ಕೆ ಸೂಟ್ ಹಾಕಿದಾರೆ ಅವರು
You see, 170 page.
17 ಅಲ್ಲಿ 20,000 ಒಂದಿದೆ
Okay, sir.
ಅದೇ 35,000 18 ಒಂದರಲ್ಲಿ
We have to-
ಎಷ್ಟು ಒಬ್ಬರೇ ಕೊಟ್ರು ಈಗ ಏನಾಗಿದೆ ಆರ್ಡರ್ ಏನು ವಾಟ್ ಇಸ್ ಆರ್ಡರ್
ಅವರಿಗೆ ಅಮೌಂಟ್ ಕೊಡಬೇಕಂತ ವರ್ಚುವಲಿ ಇಂಡಿಪೆಂಡೆಂಟ್ ಇಂಜೆಕ್ಷನ್ ಫೈನಲಿ ಇಟ್ ಇಸ್ ಗ್ರಾಂಟ್ ವಿಚ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ It's what happened. The originals are important. And maybe they are not for freelance. They say that as if it is not that case that the trade is complementary or supplementary to each other. Now the gift deed is not a conditional gift deed. Yes, we will clear as accepted by the transport.
according to you tenants are even depositing the amount in the name in the account of the plaintiff.
I have entitled as the tenants who started. They will face, they have recognized.
Now some of the tenants are also paying according to you even from 2019 to 22. Some of the tenants are paying the amount in favor of the
Sons have deposited in an account, waited. What she did. The condition.
rents are paid. ಆಕೆ ಅಕೌಂಟ್ಗೆ ಹಾಕ್ತಾ ಇದೀವಿ
Rents ಅಲ್ಲ. Sons have. Now, the sympathy shown by the track of the sympathy.
ಆಯ್ತ್ರಿ ಬದುಕಿದ್ದಾಗ ತಾಯಿ ಆಸ್ತಿ ಅಲ್ಲಿ ಏನೋ ತಾಯಿ ಮಕ್ಳು ಚೆನ್ನಾಗಿ ನೋಡ್ಕೋತಾರೆ ಅಂತ ಹೇಳಿ ನಿಮ್ಮನ್ನ ನಂಬಿ ಬರ್ಕೊಟ್ಲು ಗಿಫ್ಟ್ ಇಡ್ ನೀವೆಲ್ಲ ನುಂಗ್ಬಿಟ್ರ ಅಪಿಯರ್ ಆಗಿ ನೋಡೋಣ ಅಪಿಯರ್ ಆಗಿ ನೋಡಿ ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಸರ್ವ್ ದಿ ಕಾಪಿ ಆಫ್ ದಿಸ್ ಅಪೀಲ್ ಮೆಮೋ and the counsel appearing for the respondent. ಯಾವ ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹೇಳಿ list this matter on 37. Copies are permitted. ಹಾಗೆ ಮಾಡಿ issue notice against respondents and also counsel is permitted to take out notice and the counsel appearing for the respondents before the trial court. List this matter on 37. ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದು ಲಿಸ್ಟ್ ಆಗಿತ್ತು ನೋಡಿ ಮೇಡಮ್ ಅದೇನು ಪ್ರೆಸೆಂಟ್ ಅಷ್ಟೇ ನೋಡಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಅಪಲೆಂಟ್ 6 time get the document of the notification with regard to the enhanced compensation and hence 2 weeks time granted. List this matter on 37. HCCP is present ಅಂತ ಆಗ್ತದೆ ಯಾರ ಕೇಸ್ ಭೀಮಯ್ಯ ಯಾರ ಇದ್ರಲ್ಲಿ ಇಲ್ವರು R2 counsel is absent. Next 37. Appearing for respondents. Why madam? ಇವರ ನಂಜಾರೆಡ್ಡಿ ಎಲ್ಲ ಹೋದ್ರೆ ರಿಮ್ಯಾಂಡ್ ಇಲ್ವರು 2016 ಅಲ್ಲಿ ರಿಮ್ಯಾಂಡ್ ಆಗಿರೋದು ಸ್ಟೇ ಏನಾರು ಇದೆಯಾ ಮೇಡಮ್ ನೋಡಿ ಅಥವಾ ಅಪೀಲ್ ಇದು ಸೂಟ ಡಿಸ್ಪೋಸಲ್ ಆಗಿರ್ತದೆ ಸೂಟ ಅಪೀಲ ಏನು ನೋಡಿ ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ಲ ಅಲ್ಲ ಏನಿದೆ ವಾಟ್ ಈಸ್ ದಿ ಸ್ಟೇಟಸ್ ಆಫ್ ದಿ ಸೂಟ್ ನಿಮ್ಗೂ ಏನು ಗೊತ್ತಿಲ್ಲ ವಾಟ್ ಈಸ್ ದಿ ಸ್ಟೇಟಸ್ What is the status, madam? You are representing counsel Y.H. Vijay Kumar. So the respondent counsel 6 time. This is the appeal of the year 2016 and appellant counsel is also not present before the court. However, an opportunity is given to the appellant counsel. If appellant counsel doesn't appear in the next date of hearing, the appeal will be dismissed. List this matter on 37. Hmm. Hmm. Huh? ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರಲ್ಲ. ಹ. ಏನ ಇದ್ರ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ 10 lakhs ಅಂತ ಏನೋ ಇತ್ತಲ್ಲ, ಅವ್ರ ಡಿಮ್ಯಾಂಡ್ 10 lakhs ಏನೋ ಮಾಡಿದ್ರು, ನೀವೇನು? ಹಾ, ಅರಿಯರ್ಸ್ ಎಷ್ಟಿದೆ? ಅಷ್ಟು ನಾನು ಅರಿಯರ್ಸ್ ಎಷ್ಟಿದೆ ಕೇಳಿ ಅಂತ ಹೇಳಿದ್ದೆ. ಎಷ್ಟು? ಹಾ. ಯಾವಾಗ? ಇನ್ನು 225 ಬಾಕಿ ಇದೆ. ಹಾ, ಹೇಳಿ. ವಾಟ್ ಈಸ್ ಇಟ್? ಮೊದ್ಲಿದ್ರ ಕೆಲಸದಲ್ಲಿ ಆಯ್ತು, ಮೊದ್ಲೇಂದ್ರಲ್ಲಿ ಇದ್ದ ಹೇಳಿ ಕೆಲಸ. ಆಯ್ತು, ಬೇಡ, ಈಗ ಬಿಟ್ಬಿಡೋಣ. ಈಗೇನು ಅವ್ರಿಗೇನ ಈಗ ಪರ್ಮನೆಂಟ್ ಅಲಿಮೋನಿ ಎಷ್ಟು ಕೊಡ್ತೀರಿ ನೀವು? ಏನ್ ಮಗು ಇದೆಯಾ? ಏನು ಒಬ್ರೆ? ಆಯ್ತು, ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಈಗ? ಎಷ್ಟು ವರ್ಷ ಇದ್ರು ಒಟ್ಟಿಗೆ ಅವರು? 7 lakh. 7 ಆಯ್ತು, 2,25,000 ಅರಿಯರ್ಸ್ ಇದೆ. 7 + 2 225. ಮತ್ತೆ ಆಯ್ತ್ರಿ, ಈಗ ಆಯ್ತು. ಈಗ ಮತ್ತೆ ಅರಿಯರ್ಸ್ ನೀವು ಅದ್ರಲ್ಲೇನ್ ಕೊಡೋದು ಬರುತ್ತೆ? 2.25 ಇದೆ ಅಂದ್ರೆ ನೀವು ಕೊಡೋದೇ ಅಲ್ಲಿಗೆ 7 ಲಕ್ಷ ಅಂತಂದ್ರೆ ಬರೀ 4.25 ಲಕ್ಷ ಆಗುತ್ತೆ ಮತ್ತೆ, ಅಲ್ವಾ? ಅರಿಯರ್ಸ್ 2.25 ಲಕ್ಷ ಇದೆ ಇನ್ನು. ಅರಿಯರ್ಸ್ 2.25 ಲಕ್ಷ ಇದೆ. ಎಷ್ಟು ಆಕೆಗೆ ಏಜ್ ಎಷ್ಟು? ಈಗ 5,000 ಗ್ರಾಂಟ್ ಮಾಡಿದ್ದಾರೆ. 30 years. ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಇದೆಯಾ? ಇವ್ರಿಗೆ ಏನಿದೆ, ಮನೆ ಇದೆಯಾ? ಮನೆ ಎಲ್ಲಿದೆ?
ಒಬ್ಬರಿಗೆ 18 lakhs.
ಗಾಯತ್ರಿ ನಗರ 12.5 by. ಈಗ ಇವ್ರ ಮಕ್ಳಿಲ್ವಾ? ಫಸ್ಟ್ ವೈಫ್ ಅಲ್ಲಿ ಏನಾರು ಇದಾರ ಮಕ್ಳು? ಇಲ್ವಾ? 12 by ಎಷ್ಟಿದೆ? 45. ನಾನು ಹಾಗೆ ಜಸ್ಟ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದೆ. ನಿಮ್ಮ ಪ್ರಕಾರ ಈಗ 5,000 ರೂಪಾಯಿ ಆರ್ಡರ್ ಆಗಿದೆ. ನಿಮ್ಗೆ 30 years ಅಂತ ಹೇಳಿದ್ರಿ. ರಿಮೈನಿಂಗ್ 30 years ಬದುಕಿದಾಳೆ ಆಕೆ ಅಂತ ಅಂದ್ರೂ 5,000 ರೂಪಾಯಿ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ರೆ ಇಟ್ ಕಮ್ಸ್ ಟು 18 lakhs. ನೀವು 4.25 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಹೆಂಗಾಗ್ತದೆ ಹೇಳಿ? ಅಟ್ಲೀಸ್ಟ್ ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಕಡಿಮೆ ಮಾಡ್ಬೋದು. ಯಾವಾಗ ಅಂತಂದ್ರೆ ನೀವು ಒನ್ಸ್ ಫಾರ್ ಆಲ್ ಒಟ್ಟಿಗೆ ಕೊಡ್ತೀವಿ ಅಂತಂದ್ರೆ ಆ ದುಡ್ಡನ್ನ ಅಟ್ಲೀಸ್ಟ್ ಯುಟಿಲೈಸ್ ಮಾಡ್ಕೊಂಡು ಆಕೆ ಏನಾದ್ರು ಮಾಡ್ಬೋದು. ನಾನು ಜಾಸ್ತಿ ಲೆಕ್ಕ ಹಾಕಿಲ್ಲ, 60 ವರ್ಷ ಲೆಕ್ಕ ಹಾಕಿಲ್ಲ. ಇನ್ ರಿಮೈನಿಂಗ್ 30 years ಹ್ಯಾಸ್ ಟು ಲೀಡ್ ಅವರ್ ಲೈಫ್ ಅಲ್ವಾ? ನೀವು ಕೂಡ 4.25 ಲಕ್ಷ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತಾಳ ಆಕೆ? ವಿತ್ 30 years ನೀವ್ ಹೇಳ್ತಿರೋದು 7 ಲಕ್ಷ. ಬಟ್ ಯು ಕಂಟಿನ್ಯೂ ಟು ಪೇ 5,000 ಎವ್ರಿ ಮಂತ್ ಅಷ್ಟೇ. ದಟ್ಸ್ ಆಲ್. ಏನೇ ಸೆಕೆಂಡ್ ಮ್ಯಾರೇಜ್ ಇಬ್ಬರದು ಮೂರನೇ ಮ್ಯಾರೇಜ್ ನೋ ಚಾನ್ಸಸ್ ಅನ್ಸುತ್ತೆ ಅಲ್ವಾ? ಅಲ್ವಾ? 5,000 ನೀವು 30 ವರ್ಷ ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಇಟ್ ಕಮ್ಸ್ ಅರೌಂಡ್ 18 lakhs. ಸಿಂಪಲ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಷ್ಟೇ, ಅದ್ರಲ್ಲಿ ಏನು ಇರ್ತದೆ? ಈಗ 5,000 ಇದೆ, 5,000 ಇಸ್ ಇವತ್ತಿನ ದಿವಸಕ್ಕೆ ಜಸ್ಟ್ ಅಂಡ್ ರೀಸನಬಲ್ ಆಲ್ಸೋ. ಕಡಿಮೆನೆ, ಮನೆ ಇಲ್ಲ ಅಲ್ಲ ಬೇಡ, ಇದರಲ್ಲಿ 12/45 ಇದೆಯಲ್ಲ ಮನೆ, ಅದ್ರಲ್ಲಿ ಒಂದ್ ಸ್ವಲ್ಪ ಏನಾದ್ರು ಕೊಡಿ ವಾಸಕ್ಕಿರಕ್ಕೆ, ಕಡಿಮೆ ಮಾಡೋಣ. ಈಗ ಮನೆ ಇದೆ, ತಾಯಿ ಇಲ್ಲ, ಯಾರಿಲ್ಲ, ಅವರು ಒಬ್ಬರೇ ಒಂಟಿ. ಹಾ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, ಇಲ್ಲಿ ಇಲ್ಲ ನೀವು ಒಟ್ಟಿಗೆ ಇರ್ಲಿ ಬಿಡಿ, ಹೆಂಗಿರೋ ಯಾರು ಇಲ್ಲಲ್ಲ, ಯಾರಿಲ್ಲಲ್ಲ. 12/45 ಮನೆ ಇದೆ, ಡಿವೋರ್ಸ್ ಆಗೋಗ್ಬಿಟ್ಟಿದ್ಯಾ? ರೆಸ್ಟೋರೇಷನ್ಗೆ ಫೈಲ್ ಆಗಿದೆ, ಇರ್ಲಿ ಅದಾದ್ಮೇಲೆ ಬಿಟ್ಬಿಡಿ, ಅದೆಲ್ಲ ಬೇಡ ಈಗಿನ. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು. ಆಯ್ತು, ಈಗ ನೀವೇ ಡಿಸೈಡ್ ಮಾಡಿ ಇಬ್ರು ಎಷ್ಟು. ನಾನು ಈಗ ಕೊಟ್ಟಿದ್ದೀನಿ ನಿಮ್ ಕ್ಲಿಯರ್ ಪಿಕ್ಚರ್ ಏನು. ಅವ್ರ ಡಿಮ್ಯಾಂಡ್ ರೀಸನಬಲ್, ನಾನು ಅವತ್ತೇ ಹೇಳಿದೆ. ಅವ್ರು 10 ಲಕ್ಷ ಅಂತ ಯಾವಾಗ ಹೇಳಿದಾಗ ದಟ್ ಈಸ್ ರೀಸನಬಲ್ ಅಂತ ಅವತ್ತೇ ನಾನು ಹೇಳಿದ್ದೆ. ಬಟ್ ನಿಮ್ದು ಅರಿಯರ್ಸ್ 2 ಕಾಲಿದೆ ಪ್ಲಸ್ ನೀವು ಮಾಡ್ಬೋದು. ಕೌನ್ಸಿಲ್ ಫಾರ್ ಅಪಲೆಂಟ್ ಸೀಕ್ಸ್ 1 week ಟೈಮ್. Earlier proposal was given and the same is not finalized, and hence both parties be present before the court and list this matter on ಯಾವಾಗ 22nd or 23rd? 22nd. ನೋಡಿ ಇನ್ನೊಂದ್ಸರಿ ಮಾಡಿ. ಇದು ಸ್ವಲ್ಪ ನೀವು ರಿವೈಸ್ ಮಾಡ್ಕೊಂಡು ಒಂಚೂರು ಮೇಲೆ ಹೋದ್ರೆ ನಾವು ಮಾಡ್ಬೋದು. ಅರಿಯರ್ಸ್ ಇದೆ, 2 ಕಾಲ್ ಇದೆ. ಅದರ್ ದನ್ ಅರಿಯರ್ಸ್ ಅಂದ್ರೆ ನೋಡಿ. Next 39. ಈಗ ಪಿಟಿಷನರ್ಸ್ ಯಾರು? ವೈಫ್ ಅಂಡ್ ಚೈಲ್ಡ್, ಡಾಟರ್ ಆರ್ ಸನ್? ಡಾಟರ್. ಮದರ್ ಅಂಡ್ ಡಾಟರ್. Even granting so 2,000 up to the age of 12 years willing. You don't have other parents are no more. $7,50,000. Both wife and also daughter is also there, madam. She is aged about 6 years. Daughter only. Other than FD, you are intend to give 7.5 lakhs. Because that is only 5,000, 2,000 is ordered. Out of that only you are paying 50%. He has to provide education to the child also, madam. Award is only for 2,000 for a daughter. Till the age of 2 years. After 2 years, 4,000. How could she maintain a daughter with provide an education? Huh? Agriculture background ಆಯ್ತು ಏನ್ ಮಾಡೋದು? ಹ. ಹ್ಮ್. ಹ್ಮ್. ಆಯ್ತು ಮೇಡಮ್ ಹಾಗಂತ ಹೇಳಿ ಗ್ರ್ಯಾಂಡ್ ಮದರ್ ನೋಡ್ಕೊಳ್ಳಿ ನೀವ್ ಹೇಳಕ್ ಆಗಲ್ಲ. She is a daughter of you. ಹ್ಮ್. ಗ್ರ್ಯಾಂಡ್ ಮದರ್ ಜೊತೆ ಇಲ್ವಾ? ಮದರ್ ಜೊತೆಲೇ ಇದೆ. ಏನಂತ? ಅವಾಗ ಎದ್ರು ಇರ್ಬೋದು ಮೇಡಮ್, ಈ ಸ್ಕೂಲ್ಗೆ ಹೋಗ್ತಾ ಇದೆ ಅಂತ ಚೈಲ್ಡ್. ಆಯ್ತು ಹೇಳಿ, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ. ಐ ಥಿಂಕ್ ಯು ಆರ್ ನಾಟ್ 7.5 ಲಕ್ಷ ಅಂತ ಅವ್ರೇನು ಹೇಳ್ತಾರೆ. Plus 3 lakhs is in deposit FD. Yes. ಬಟ್ ಈಗೇನ್ ಡೈವರ್ಸ್ ಆಗಿಲ್ಲಲ್ಲ, ಗಂಡ ಹೆಸರಿಗೆ ಗಂಡ ಇರಬೇಕು, ಬಟ್ ನಾಟ್ ರೆಡಿ ಟು ಲಿವ್ ಇಟ್ ಅಂಡ್ ಮೇಂಟೆನೆನ್ಸ್ ಮಾತ್ರ ಬೇಕು. ಹ್ಮ್. ಈಗ ನೀವೇನ್ ಹಾಕಿಲ್ಲಲ್ಲ, ಫೀಲ್ ಹಾಕಿದಿರ? ಇಲ್ಲಲ್ಲ, ಇರೋದೇ 7,000 ಆರ್ಡರ್. 5+2 to the age of 12. So he was in Armina. Hmm. 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 No, what is the status of MC 29 of 2017? For withdrawal. MC number 29, not before this. Separate. Mother's house instead of looking in well manner. She further deposit and was sent to her mother's place instead of she had went to husband went to his. It was informed. Chances is ನೋಡಿ ಅಂತ. MC ಏನೋ ವಿಡ್ರಾ ಮಾಡಕ್ ಮೆಮೊ ಹಾಕೋರು. ಆಯ್ತು. No grounds for reducing an amount of rupees 5,000 and 2,000. Madam, this proceeding 125 scope is only court has to see the status of the case and grant the maintenance. Here is an ex-serviceman and getting pension of rupees 12,000 and odd. Now, I think trial court divided on that basis only. Other than even he is having the property. 5,000 plus 7,000. 5,000 for wife, 5,000 for husband, 2,000 for child. That is. And constructed the house also. ನೀವು ಮನೆ ಕಟ್ಟಕ್ಕೆ ಹೇಳ್ಬಿಟ್ಟು ಹೊಸ ಹೋಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾರ್ರಿ ಅವರು? Madam, other side is not ready even settlement for your proposal. 7.5 lakh also. Anyhow, you have constructed a house and you are having a house. That's all. Sure. How do they? Madam, two persons have to leave out of rupees 7,000, and also she has to provide an education to her child also. What is the basis for reducing the amount? Then let him. Supreme Court and High Court says it is bound on duty if bodily able person can earn and provide maintenance. Madam, ಹೆಂಡತಿ ಮಗುನು ಊಟ ಮಾಡ್ಬೇಕಲ್ಲ ಮೇಡಮ್, ಅದಕ್ಕೆ ಕೊಟ್ಟಿರೋದು ಮೇಂಟೆನೆನ್ಸ್. ನಿಮ್ಗೂ ಅವರಲ್ಲಿ ಏನೋ ಬಹಳ ವ್ಯತ್ಯಾಸ ಇದೆಯಲ್ಲ. ಬನ್ನಿ ನಾವು ಡೈರೆಕ್ಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು. ಅದರ್ವೈಸ್ ಒನ್ ಟೈಮ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಏನಾದ್ರು ಮಾಡ್ಕೊಳಂಗಿದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಹ್ಮ್ 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 That's all. Good. 5,000 for two persons. 2,500 2,500 ಇಬ್ರು ಬದುಕೊಂಡು ಇಬ್ರು ಎಜುಕೇಶನ್, ಅವಳಿಗೆ ಮಗುಗೆ ಎಜುಕೇಶನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತಾ ಮೇಡಮ್? Actually, this is reasonable amount what the trial court has ordered. That's all. Told. Heard the petition of counsel and also the counsel appearing for the respondent. Sir, grievance we'll see. Told. It is granted early as extended till next date of hearing. The respondent counsel is directed to keep the respondent present before the court. And this matter on 23rd. 23rd. 23. ನೀವೇನು ಅನೌನ್ಸ್ಮೆಂಟ್ ಕೇಳಿದಿರಾ? ಯಾರು ನೀವು ಅನೌನ್ಸ್ಮೆಂಟ್ಗೆ? ಹಾ, ಆಯ್ತು. 4,000 ಈಚ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇದ್ರಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡೋದು? ಹಾ 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 ಹ್ಮ್ 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 Partition suit also you are paying 4,000. What is the land you are having? 21 guntas. Out of that 11 guntas to son. ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ ಏನ್ನ? RFA ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? ಆಯ್ತು. ಎಲ್ಲಾ ಪ್ರಾಪರ್ಟಿ ಇದ್ದಿದ್ನ ಮಾರಾಟ ಮಾಡಿ, ತಂದೆ ಹೆಸರಿಗೆ ಮಾರಾಟ ಮಾಡಿ, ಇವ್ರ ಹೆಸರಿಗೆ ಮಾತ್ರ 20 ಗುಂಟೆ ತೋರಿಸಿ. ಆಯ್ತು, ಅದು ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಅದು ಸಪರೇಟ್ ಇರ್ಲಿ ಬಿಡಿ. Came to be dismissed on what ground? What is the ground for dismissal? Trial is trial.
And the husband will have immediate income and she is living there and she is resident to the night who is the bond and she is well.
That order has been set aside and remitted back to the trial court.
And what is happening here? Because the trial court immediately gone to the trial court analyzed that. Is that I come with challenge. Now what is happening here? One to be dismissed by the same court. And after also and now because the market export and there is no evidence. Nothing is structured. And therefore we brought it in for sanction. He said that he's also got a partition. I will be challenged and then to prove that I'm not coming in. Only thing is the enactment of 4,000, 8,000, and this was as well is not earning day-to-day income. And the price the respondent gave him the he has not disability. Makes an observation.
Paragraph. Hale and healthy young man, he has no disabilities, he has a lucrative share business. If he had suffered any loss and was unable to conduct his business, he ought to have produced his income tax returns, which would have the best evidence to prove his income. Further, Exhibit P22 to 28 B structures reflect that his respondent had owned several vehicles, including luxury cars. Of course, the respondent has subsequently produced Exhibit 9 to 11 to show that those vehicles are not standing in his name. But it is relevant to note that the respondent has transferred these vehicles to the name of his own father. Further, his transfer has taken place after the beginning of matrimonial dispute between the parties. Therefore, it appears that this respondent has cleverly transferred his assets to the name of his father in order to plead no income. Say move by the respondent fails to inspire the confidence. Then why you have transferred the vehicle in the name of father? With an intention to defeat the claim of the wife only. Considering the documents Exhibit P9 to 14 as well as Exhibit 22 to 28, passed an order that you have transferred the vehicle in the name of the father after the commencement of this miscellaneous proceedings. Whatever it may be, you are having vehicle also the doing business also, even if assuming that you are having the business. Then why you have not placed income tax details before the court? Now, in view of the judgment of the Supreme Court, you have to bound to place all materials before the court, your assets and liabilities. Because these matters are 2015 matter. That's why Supreme Court noticed matters are pending before the family court, issues are pending before the courts for decades. That's why directed to pay. No concern, no ground. New produce ಮಾಡಬೇಕು. If she is working, you have to produce the documents. She cannot produce the evidence saying that no. You have to produce if she is earning. No counsel. Ground. MBA graduate, wife also MCom graduate. ಹೌದಾ? ಹೇಳಿ. ಎರಡು ನೋಡ್ಬೇಕು, ಒಂದೇ ಅಲ್ಲ. ಅವ್ನು ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಾನೆ, ಬಿಸ್ನೆಸ್ ಮಾಡಕ್ ಶೇರ್ ಬಿಸ್ನೆಸ್ ಅನ್ನೋದಕ್ಕೆ ಏನಾದ್ರು ಮೆಟೀರಿಯಲ್ ಹಾಕಿದೀರಾ? ಸ್ಕೂಲ್ ಫೀ ಬಿಲ್ಸ್ ಆಫ್ ಸೆಕೆಂಡ್ ಪಿಟಿಷನರ್ ಬಿ ರಿಜಿಸ್ಟರ್ ಎಕ್ಸ್ಟ್ರಾ 22 to 28. ಎಷ್ಟು ವೆಹಿಕಲ್ ಇದ್ದವ್ರಿ ಅವ್ರ ಹೆಸರಲ್ಲಿ? 22 to 28 22, 23, 24, 25, 26, 27, 28. 7 vehicle. Translation copy of partition deed exhibit P9. Partition ಆಗಿತ್ತಾ? ಡಾಕ್ಯುಮೆಂಟ್ ಈಗ 20 ಗುಂಟೆ ಮಾತ್ರ ಕೊಟ್ಟಿರೋದು. ಎಷ್ಟಿದೆ? ವಯಸ್ಸೇನು 101 of 2015. ಎಷ್ಟು ಹೇಳಿ ಹೋಗ್ಲಿ, ಈ ಪ್ರಕಾರ ಎಷ್ಟಿದೆ? ಯಾರ್ದು? ಮತ್ತೆ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡು, ಇಫ್ ಇಟ್ ಇಸ್ ಸೆಲ್ಫ್ ಅಕೌಂಟ್ ಪ್ರಾಪರ್ಟಿ, ವೈ ಪಾರ್ಟಿಷನ್ ದಿ ಪ್ರಾಪರ್ಟಿ? ಆಲ್ conduct shows that your client is avoiding payment of maintenance. ಮಲ್ಲೇಶಪ್ಪ ಪುದಪ್ಪ ಇವರಿಗೆ ಈ ಒಟ್ಟು ಕುಟುಂಬದ ಉತ್ಪಾದನೆಯಿಂದ ರು 50,000 ನಗದಾಗಿ ಪಡೆದಿರುತ್ತಾರೆ. ಅದನ್ನೇ ಹೋಗಿದ್ರೆ ಗ್ರಾಮದ ಇದು ಫಾದರ್ ಅಂಡ್ ಸನ್ ಮಾತ್ರನಾ ಪಾರ್ಟಿಷನ್? ಸಿಸ್ಟರ್ಗೆ 4 ಗುಂಟೆ 20, 4 ಎಕರೆ 20 ಗುಂಟೆ. ಎಕರೆ ಸರಿ ಅಡಿಕೆ. ಇವನಿಗೆ ಬಂದಿರೋದು ಯಾವ್ದು ಐಟಮ್? ಇಪ್ಪತ್ತು ನಂಬರ್ 9. ಎರಡನೇ ಪಾಠೆಯ ಯಶವಂತ ಒಟ್ಟು ಕುಟುಂಬದ ಉತ್ಪಾದನೆಯಿಂದ 10 ಲಕ್ಷ ರೂಗಳನ್ನು ನಗದಾಗಿ ಪಡೆದಿರುತ್ತಾರೆ. ಇವ್ರದ 10 ಲಕ್ಷ ತಗೊಂಡಿದಾರೇನ್ರಿ? 22 ಗುಂಟೆ ಜಮೀನು. ಸಿಸ್ಟರ್ಗೆ 5 ಲಕ್ಷ. ಇನ್ನೆಲ್ಲ ಆಸ್ತಿನ ಅಪ್ಪನ್ ಕೊಟ್ಬಿಟ್ರ? ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಏನಿದೆ ಎಕ್ಸಿಬಿಟ್ P15, P57. ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಕಾಪಿ ಆಫ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಂತ ಇದೆಯಲ್ಲ, ಯಾಕೆ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಅದು ಕನ್ನಡದಲ್ಲಿ ಇದೆಯಲ್ಲ, ಅದಲ್ಲ ಮೋಸ್ಟ್ಲಿ ಬೇರೆ ಇರ್ಬೇಕು. ಇದಾದ್ರು ಎಕ್ಸಿಬಿಟ್ P57 ಅಂತ ಇದೆ. Partition deed dated 5/3/2014. 54, 57. ಎಷ್ಟು ಏಜ್? What is the age of the child? 14 years. Told. These 2 petitions are filed. Remaining matters are 230. These 2 petitions are filed. Being agreed by the order of the trial passed in criminal miscellaneous number 18 of 2015. Grant maintenance of rupees 4,000 each to the wife and a daughter or the son? Son. And wife also filed a petition. For enhancement. The factual matrix of the case is that the first petitioner married the first petitioner in criminal miscellaneous number 18 of 2015 married the respondent on 28/2007, and in the said wedlock she gave birth to a second petitioner who is aged about 7 years at the time of filing the petition in 2015, and is under the care and custody of the first petitioner. The petition allegations are made against the husband, started ill-treating the wife both mentally and physically, demanding to bring money. And also case of the wife that as per the demand, parents have paid the amount of rupees 1 lakh cash and gold ornaments worth rupees 6 lakhs as dowry at the time of marriage. The respondent was coming home late night, inebriated, and used to assault the wife mercilessly, which leads to file a claim petition for claiming maintenance. Earlier, it was numbered as 39 2009, and the same was dismissed and as against in petition under DV Act. Petition under DV Act 2005 seeking maintenance not to commit any further act of domestic violence. The said petition was partly allowed, granting monthly maintenance of 4,000 to the petitioners. The respondent has challenged the same in criminal appeal number 107 of 2012 before the fast track court. The same was dismissed. In the meanwhile, the first petitioner preferred an appeal in criminal appeal number 134 of 2011 for enhancement. The same also dismissed. The respondent has failed to pay the maintenance amount of 4,000. Hence, he filed the respondent also filed a petition seeking divorce in MC number 134 of 2013. The same came to be dismissed on 36/2014. He also filed GNWC 21 of 13 seeking custody of the petition number 2, and the same was also dismissed. It is contended that both are unable to lead their life. The partly amount of 4,000. And also contend that second petitioner is studying in 3rd standard at Sai Angel School. And yearly expenses would be rupees 60,000. It is also contended that respondent is doing share business, having good income and also got income more than rupees 70 lakhs per year from agricultural properties. He owns site worth of rupees 25 lakhs at Shivamogga city and is capable of maintaining the petitioners. Respondent is not maintaining. The petitioner are facing difficulties. And first petitioner is also unemployed. Maintenance of rupees 40,000 per month. Earlier, the said petition was dismissed in 2016 by placing the respondent ex parte. As per the order passed in RPFC number 63 of 2016, that order was set aside and matter was remanded back to the court for fresh disposal. The respondent also appeared and filed the statement and admitted the marriage. They have denied the all other arguments made with regard to the payment of cash dowry and also the gold ornaments for worth of 6 lakh. Reiterated with regard to the earlier proceedings before the respective courts. It also contended that second petitioner also filed a suit. Voice number 101 of 2015 for partition and separate possession of the second petitioner. The said suit was partly decreed, granting 11 guntas of land. It also contended that as per the earlier order, miscellaneous number 239 of 2009, respondent has paid up to date maintenance amount. The trial court allowed both parties to lead their evidence and wife examined herself as PW1 and got marked document exhibit P1 to P68. On the other hand, husband examined as RW1 and he also relied upon the documents of exhibit R1 to R15. The trial court, having considered oral evidence and documentary evidence, while assessing the maintenance, discussed the earlier order passed by this court and also the judgment of the apex court, that is Rajneesh versus Neha case, and also the other judgments of this court. Having considered both oral and documentary evidence in paragraph number 29, take a note of the earlier order directing to pay an amount of 4,000 under the Domestic Violence Act in petition number 239 of 2009. And also in paragraph number 13, take a note of the court passed in petition number 1265 of 2015. Having considered material and record in the revision in this petition that the court below in RPFC 70 of 2021, that trial court fails to consider that the petitioner is not having any definite income to pay the maintenance. Trial court committed an error in not relying upon the document of exhibit R1 to 15. Now, contrary to exhibit P1 to exhibit P68, does not give any indication for allowing the petition. The order input is very illegal and unsustainable and contrary to the evidence, and when he is unable to pay maintenance, since he was not having any income, granting of maintenance of rupees 4,000 each is erroneous. Per contra, the counsel appearing for the respondent, one of the respondent in that RPFC 70 of 21 and the petitioner in RPFC 114 of 21, contained that the court below fails to take note of the material and record. The husband is having source of income through his agricultural land. Though partition took place between the respondent and his father, only small share is allotted to the respondent only to deprive the petitioner from claiming the property through harassment. Apart from that, exhibit R9 to 13 clearly indicate that the father of the respondent owns several luxury vehicles, having several acres of lands. Also, document exhibit P to 22 to 28 clearly discloses that those cars are in the name of earlier the husband, and after the commencement of the proceedings, only both those vehicles are sold. Father, and the same was also taken up maintenance. Having heard both the counsel, also on perusal of material, find that to arise for the consideration of this court, whether the trial court committed an error in granting maintenance of rupees 4,000 each, whether the trial court committed an error in granting meager maintenance of rupees 4,000 each. Court order. Having heard both the counsel and also on perusal of material, there are no dispute with regard to the fact that marriage was solemnized in 2007. Also, no dispute with regard to the dispute was arised between the parties immediately after the marriage, and the same leads to file a petition in criminal miscellaneous number 239 of 2009 under Domestic Violence Act. And also no dispute that a maintenance of rupees 2,000 was awarded in that petition. The same is also challenged before the court by both the sides, and both are dismissed. The present petition is filed in 2015 seeking maintenance. ಈಗ ಆ 4,000 ಕೊಡ್ತಾ ಇದ್ದಾರಾ ಅಥವಾ ಅದು ಇದ್ರ ಜೊತೆಲೆ ಮರ್ಜ್ ಆಗಿದೆಯಾ? Now she is getting 12,000. ಈಗ ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಈ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿತ್ತು. ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಪೇಯಿಂಗ್. ಹೌದಾ, ಕರೆಕ್ಟಾ? ಸರಿ, ಏನಾಯ್ತು ಮೇಡಮ್? And no dispute the fact that in terms of the earlier order passed in criminal miscellaneous number 239 of 2009, the husband is making the payment of rupees 4,000. Now, apart from the said amount, the trial court passed an order directing to pay an amount of rupees 4,000 each, and total will be rupees 12,000 for the wife and the son. Having perused the material at the time of filing the petition in 2015, the son is aged about 7 years. Now he would be aged about 13, 14 years. And also not in dispute that the second petitioner is pursuing the education. Earlier it was stated that he was pursuing the 3rd standard at the Sai Angel School, Chikmagalur, and wife claims that the fee would be rupees 60,000. In order to prove the said fact, also produce the school fee certificate. That is Exhibit P 10 to 21. That is school fee bill of second petitioner. And also the petitioner relied upon, the wife also relied upon the document of Exhibit P 22 to 28 B Register Extract, which discloses that husband was having those vehicles, and the same was transferred subsequent to the dispute between the wife and husband. And the same is also observed by the trial court while considering material on record. And the said vehicles are transferred to the father in terms of document Exhibit R9 to R14. It is also the case of the wife that husband is pursuing in the business, share business. A counsel appearing for the wife also brought to notice of this court the partition deed effected between the father and the son, and also sister of the, and also the daughter, other daughter of his father, wherein husband has received an amount of rupees 10 lakhs, and also a 51 kuntas of land. It is also not in dispute that suit is also filed for the relief of partition by the son, wherein 10 kuntas of land was given to the second petitioner. And also counsel submitted that an appeal is pending before this court in RFA. RFA pending before this court. RFA number enaridiya? RFA. This court cannot look into the material with regard to the partition is concerned, and the same has to be adjudicated in a separate forum. But only court has to take note of the present cost of living and standard of living. And also, no doubt, the father has got major share in the said partition. Same cannot be considered, but only court has to look into the status of parties. And having taken note of already getting 4,000 in view of the order passed in domestic violence case in CMS number 239 of 2009, and also the present order in criminal miscellaneous number 18 of 2015. And the second petitioner is also pursuing son is also pursuing his education at Chikmagalur. And taking into note of school fee as well as school fee he has not paid. Hodala, till date he has not paid. And also the same is borne by the wife herself. Out of 12,000, it is very difficult to maintain herself and also maintain the child who is pursuing the education and aged about 13 years and to meet the expenses, school fee expenses. Hence, it is appropriate to modify the order of the trial court enhancing the maintenance to wife instead of rupees 4,000 each to the son, and also taking note of the other amount of rupees 4,000 already paying under criminal miscellaneous number 239 of 2009, in total 12,000. For the child, it is enhanced to 8,000 in criminal miscellaneous number 18 of 2005, since the wife has to meet the educational expenses. Including the criminal miscellaneous number 239 of 2000, miscellaneous number 18 of 2015. The same is payable 16,000. In respect of wife, in the criminal miscellaneous number 18 of 2015 is not enhanced. It is already getting another 4,000. The criminal miscellaneous number 239 of 2015. And in all, the maintenance is payable is rupees 16,000 to wife and the son. And hence I answered the point as accordingly. In view of the discussions made up, I pass the following order. Petition allowed, petition filed by the husband is dismissed and petition filed by the wife is allowed in granting additional maintenance of rupees 4,000 apart from the amount already ordered by the trial court in criminal miscellaneous number 2009 as well as 18 of 2015. Serial number? ಇವುಗಳ ಹೇಳಿ ಯಾವ ಬೇಕು ಅಂತ